The second question period is for the Minister for Treasury and Resources, and Conatable Greville.
Thank you, sir. The Lactation 2 coin hoard was uncovered in 2012, which is 9 years ago. My understanding is that finally the payment to the finders has been agreed by the Council of Ministers and all other parties involved. Why has the payment not been made, and when will it be paid?
Minister.
Thank you, sir. It's a very good question, and I thank the Conatable. This has been going on, in my opinion, for far too long, with the people being denied their rightful payment for their findings. Already £750,000 has been paid for the restoration, for want of a better word, of the hoard, and the price of £3,512,000 is due to be paid. It's been agreed with the Crown, and we should have this payment agreed by the end of this week. I will let the Conatable know first when it's been agreed. But it has been too long, and I know one of the people involved has already passed away, so it should not carry on any longer. Thank you.
Supplemental there?
No, sir, but I do thank the Minister for her answer, and I look forward to hearing the news later in the week. Thank you, sir.
Conatable St John.
Thank you, sir. Can the Minister advise the Assembly of the forecast impact on returns, both dividend and tax, from JT for the next 5 years following the sale of the Internet of Things?
Minister.
Thank you, sir. The dividend being the, I just want to be quite sure I'm answering the question correctly, from the £40 million, is that?
No, the dividend that we will receive as a shareholder of Jersey Telecom.
Right, so not the IoT, sorry, I'm not quite sure which one the...
I'm asking what's going to be the impact on the government's revenue from JT, both as a tax and a dividend, following the sale of the IoT.
Right, so following the sale of the IoT, the £40 million will be transferred into the coffers, for want of a better word, but will be reconstructed towards JT for investment in their infrastructure.
Supplemental.
So the question is what the impact is on the revenue in terms of dividends and tax from JT following the sale. It's not about the special dividend.
Okay, thank you very much for that clarity. We don't actually know what the future situation will be on the dividend impact at all. So we'll continue to review it. We're in constant talks with JT, and we'll come up with some answers, but it's quite a recent sale, so we don't know at this stage.
So,
Supplemental, yes?
yes, please, sir. Is the Treasury Minister telling us that she doesn't know the impact on the annual revenue from JT following the sale of Internet of Things, and therefore how does she come to the value of the sale?
Because the £40 million from the sale of the Internet of Things is going to be reinvested, we don't know what the impact is going to be.
Deputy St John. Sorry, Deputy St John, I thought. Right.
No, sorry, I was asking,
No, that's quite all right, Deputy. Sorry, I misread the chat. Deputy Aye.
Thank you, sir. In a recent public hearing, the Minister mentioned that the 1% of government expenditure allocated to culture and heritage might have to be increased. How much does the Minister expect this funding to be increased by? Thank you, sir.
Again, sir, that's a question that's speculative. It was agreed, I think it was a proposition by Deputy Tadier, that 1% of funding would be given to heritage. I'm a very keen supporter of heritage, but as yet, in the government plan, it's not been pursued as to how much more would be, or what the percentage would be.
Supplemental, Deputy Aye.
Thank you, sir. Will the Minister bring forward a proposition before the end of this term to propose an increase to arts funding? Thank you. Will you bring forward a proposition before the next election to increase arts funding?
I will certainly work on that because I'm a very big supporter of heritage and older buildings and feel that they should be supported. So I will not promise to do that, but I would like to do that.
Senator Moore.
Thank you, sir. The Chancellor of the Exchequer in the United Kingdom has told the Conservative Party conference that he thinks excessive borrowing is immoral. Would the Minister agree, and would she, and what is her opinion of borrowing exceeding a small nation's annual expenditure?
Minister.
Thank you. I certainly do not think borrowing is immoral because of the reason it has to be done, which is in order to build a hospital, which we desperately need, which the Senator is very aware of. And the UK are in a completely different situation from Jersey. We have huge reserves and borrowing against those reserves, which keep our credit ratings, is well-known phrase of mine. And I think that we are in a very, very different situation, not comparable whatsoever with the UK. Thank you.
Supplementary,
Okay,
sir.
yes.
The question actually referred to excessive borrowing, which was the quote from the Chancellor. And also if the Minister could respond to the part of the question that referred to, would she consider that excessive borrowing was borrowing that matched or exceeded a small nation's annual expenditure?
Excessive is relative. And no, I do not think it's excessive at all to borrow for the reasons that we're doing, with everything in place to repay that borrowing. So no, I don't think it's excessive.
Well, Deputy Ward.
Thank you, sir. May I ask the Minister how far the Minister has got with the implementation of the classifications of functions of government proposition P94 2019, which was accepted as amended by the Minister and states that this classification will be in place for the government plan 2022. Thank you, sir.
Thank you, sir. May the Deputy remind me what P94 was, please?
I can, sir. I can actually read it out.
For the public as well.
To request the Minister for Treasury and Resources working with Statistics Jersey to require all states' expenditure to be classified in accordance with the United Nations classifications of functions of a government system, so the annual accounts of the states of Jersey and all subsequent government documents presenting financial information, including the Government Plan 2022, classify public spending in accordance with international best practice. Thank you, sir.
Thank you very much for that clarification, Deputy. And yes, we've just issued the 6 monthly reports and accounts. And of course, we'll do so again at the end of the year, all in accordance with what the Deputy's just described. Thank you.
So, so it's not a supplementary, but actually, so that's, I believe that's not actually accurate because it's not.
Well, it is the answer. It can't be challenged as to its accuracy. Would you like a supplemental question?
Yes, please, sir. So may I ask when the actual classification system as passed by this Assembly in 2019 will be implemented? That gives classification of our spend against international spend, so we have a much clearer picture of how we actually spend on health, on education, against international markers. It would be very, very useful, in particular before the next general election on this island, where people will get a true vision, picture of what we actually spend. Thank you, sir.
Minister.
Thank you. I will get back to the Deputy as to when that can be released to the Assembly. Thank you.
Deputy Tadier.
Thanks, sir. Has the Minister heard the argument put forward that when it comes to the Social Security pension, that pension is received, they're effectively double taxed because they pay they've paid social tax on their Social Security contributions, and then they've been taxed on the actual state pension itself. And what does she think of that, if so?
That's been a long-held question, Deputy, from when I was in Social Security as Minister there. And there is not a situation of double taxation in as much as the Social Security pension paid by Social Security is not taxable. It's the entire income that is subject to tax if the income is above the £16,000 tax threshold. Thank you.
Supplemental, Deputy?
Yeah, there is a supplemental, because at best that answer I think was using sophistry, which the minister might accept, but did she accept that the whole point is that does she agree you are taxed on your social security contributions, so on your gross income, and there is no allowance, there's no the state pension isn't tax deductible, so it contributes to the overall income on which you may be taxed if you go over the threshold?
Yes, if your income goes over the threshold, then of course, as I said in my previous answer, there is of £16,000, there is a tax applicable, but it's not. I wouldn't term it as double taxation. It's just your entire income.
Well, Deputy Morell?
Thank you, sir, and apologise to the Minister. I said I had no questions, but I thought of one. In the event that the strategic reserve doesn't provide a return in any given year, certainly a return that is insufficient to pay back interest on bonds, what will Treasury do to ensure that interest payments are made?
I think probably the Deputy knows the answer to this question, but the strategic reserve, along with the Social Security Reserve, have produced excellent results. The strategic reserve of 8.1% return, despite a drop at the start of COVID of 30%, has recovered. And of course, the income forecasting group have said this will continue, but until we know exactly what's going to happen over the next few years, but the positive attitude that we have to the interest return on the strategic reserve and the Social Security Reserve is very good.
So if I may reiterate my question, because the income forecasting group are not fortune tellers. In the event that the strategic reserve does not provide a return sufficient to pay interest on bonds taken to finance the hospital, what will Treasury do to pay that interest?
Having had all the advice that we have, and of course this is going to be part of the hospital debate in the forthcoming day or so, all the huge advice that we've had on bonds for the hospital and the borrowing, which I know is part of the future debate, is that the strategic reserve will continue to fund the borrowing by putting bonds into the reserve, and the revenue from that interest will easily fund the hospital. If there's another downturn or a 2008 crisis, then we have to deal with that when we have to deal with it.
Thank you, sir.
Okay. Deputy Sultan.
Thank you, sir. And if I could return to the Constable of St John's question, every year in the past we have received a revenue in terms of tax on profits, and secondly a dividend on our shareholding in Jersey Telecoms. What were those in the year 2020 or 21? What's the ongoing dividend and tax we're receiving from JT?
Thank you. We don't have the figures as to what, I think it was in answer to an earlier question, of what the results of the revenue from the dividends are as yet. We just don't have it. There's a very big difference, which I think has got quite a few people confused, in the shareholding of which Treasury and Exchequer are the shareholders of Jersey Telecoms, and what is the sale of the IoT. So it's just a bit confusing as to what the public may see as two confusing things, which they are not. They're very separate.
Supplementary.
Yes.
What is the latest figures that the Treasury Minister has for the dividend return and the revenue produced from taxation on JT? What's the latest figure? What year?
As I said before, so we don't have that yet.
Very well. Second question, Conetable St John.
Thank you, sir. And I'm not confused at all. Could the minister tell us what the plan is to replace the income from both tax and shareholder dividends going forward from JT? Thank you.
Thank you, sir. There's a lot of questions on Jersey Telecoms here. I'm not on the board of Jersey Telecoms, and when I get the information, I can bring it to the Assembly.
You may have time for a very quick supplement.
So we've just sold an asset and the minister is telling us she doesn't know the value or the revenue of that asset. Can she tell us how she came to a decision, please?
It wasn't my decision at all. It was the board's decision to sell IoT. And I think, again, this is where there's a bit of a lack of knowledge in as much as it was a board decision, not mine. Because it was a separate business from the shareholder business, which of course, which I'm involved, but the Internet of Things was a separate business completely that was sold. So it was a board decision. I was informed, but only a week or 2 weeks before the sale because of the commercial confidentiality of it.
That's the question. Time for questions to this minister has come to an end. The final period of questions directed to the Chief Minister, Deputy Higgins.
Thank you, sir. As Chairman of the State's Employment Board, will the Chief Minister issue instructions to all civil servants that they must follow the letter of the General Data Protection Law, not only in meeting the 28-day response time, but also the need to provide all information held? One person I've been helping has had 7 attempts, got 250 documents on the first attempt and 7 more to get 1,500 pages, and the Department of Social Security is still holding out. Is that acceptable?
Chief Minister.
Sir, don't know the exact details that the Deputy is referring to. As ever, I'm very happy if you want to send me the specifics and we can look into it. And thirdly, sir, I will certainly ensure that the issues around GDPR and responses are raised with the relevant parties through SEB. I will just say, sir, I'm not entirely sure that actually is a direct employment matter, which would be SEB, but as a principle, sir, I'm very happy to raise the matter. I will accept, sir, there are sometimes quite legitimate and practical issues that do arise, which I think would be helpful to understand what the Deputy is alluding to, and hopefully at some point we can sit down and talk it through, sir.
Supplemental question, Deputy Higgins.
Yes, sir. And I hope we can also talk about the fact, if he will speak with the Information Commissioner's Office, where states departments are deliberately withholding information, and even the Information Commissioner's Office is having to spend a great deal of time and effort trying to get them to follow the law. So my question is, will the Minister discuss that with me as well? Thank you.
I'll discuss anything that the Deputy would like to discuss, sir. So I think the best bet, sir, is if we make sure that we get a date in the diary, sir.
Thank you.
Conetable St Lawrence.
Thank you, sir. What have the Chief Minister and the Home Affairs Minister done to assure themselves and thereby to reassure the public that the vetting checks undertaken on States of Jersey police officers are rigorous and to the highest standard?
Chief Minister.
Sir, I will have to go back to the specific. If the item is being raised in relation to the very tragic, that's not the right word, sir, but hideous incident that's happened in the United Kingdom, and even more recently a further, I can't remember if it's an allegation or charge, sir, against another member of the police, then, sir, that will be something specifically for the Minister of Home Affairs. And I'm absolutely in agreement, sir, of making sure that our tests are as rigorous as they possibly can be, sir. Our vetting.
Supplemental question, Constable St Lawrence.
Yes, please. So I was going to ask the Chief Minister what the vetting checks are, but clearly he can't tell the Assembly or the public, and it's extremely disappointing that following the tragedy in the UK, when we know that vetting is being closely scrutinised, that he has not yet had the opportunity to meet and discuss this with the Home Affairs Minister. My question to the Chief Minister then is, will he guarantee that he will have such a meeting with the Home Affairs Minister and with the Police Chief, please, and then come back to the states to reassure us and the public that the vetting procedures are to the highest standards? Thank you, sir.
Firstly, sir, I would expect them to be of the highest standards, but I will absolutely ensure that meeting takes place. And actually, probably more, as well, sir, I will also make sure that council ministers receive a full and appropriate briefing, sir. Okay.
Deputy Doublé.
Thank you, sir. Beyond any work being carried out by the Home Affairs Department, what is our Chief Minister doing or planning on doing to challenge rape culture and eradicate the specific issue of male violence against women and girls?
Sir, I'm slightly, more than somewhat concerned if the deputy feels she has evidence of such a culture in our Jersey workforce there, in terms of within the public organisation. If that is the case, then sir, I would very much welcome her evidence and her information. Otherwise, sir, she is, I believe, aware or has been briefed at various times by the Conatable St. Juan in his capacity as Vice Chairman of the SEP on the various pieces of work that are going place in terms of diversity training, encouraging the I Will campaign and things like that, sir.
Supplementary.
Yes, Deputy.
I'd be happy to have a discussion with the Chief Minister about the definition of rape culture, because it's not confined to the workforce. It's a societal issue which is across all societies. But as a man in one of the ultimate positions of leadership on our island, what message does the Chief Minister have for the men of Jersey on how they can be effective allies for women, please?
So I think the fundamental is that one should show respect in the context that the deputy is referring to, that men should be showing respect for women.
Senator Mezek.
Thank you, sir. Could the Chief Minister indicate what the plans are for the long-term future of the Child Development and Therapy Centre, given that it's one of those services that will have to be relocated because of the building of the hospital at Overdale, and if there is currently no long-term plan to find a site for it to operate from, when will such a plan be clear?
So the last update I had is that obviously it is being moved, as far as I'm aware, so up to Lekeneve as part of the move away from Overdale. And so the my understanding is that there has been some discussions with sites who I believe operate that particular service, either operate or very heavily involved in that particular service. And so there are some alternatives being suggested, i.e., so as far as I'm aware, it is the operational side that are, as it's been suggested to me, are not in favour of going back to the Overdale site in general, sir. So in other words, there is a plan, and sorry, there are therefore options being looked at, sir. I'm very happy to provide some more information to the Senator and to members by way of a short briefing note, which I'm sure can be arranged, sir.
Supplemental, Senator?
Yes, please, sir. And of course, it's one of the tragedies that service has to relocate, because it's one of those that is actually operating from a very good building up at that site and doing fantastic work up there, but it will be inevitable because of the hospital project. Would the Chief Minister endeavour to give to States members, as soon as is possible, some sort of indication of when a plan will be in place for their long-term future, so that those who those families where the children benefit from the services that are provided there can have some certainty that the services there will be found the best possible home, and that will be considered a matter of priority?
Chief Minister.
Yes, sir, sorry, I was on mute. Firstly, sir, the point is there will be certainty for the next few years as part of the move up to Llanelli, sir. But absolutely, as part of that note, in terms of the longer term, there's no problem. I'll make sure that's included in that note, sir. Thank you.
Deputy Morell.
Thank you, sir. Does the Chief Minister believe, as a matter of principle, that children should be able to undergo medical procedures without the consent of their parents?
Sir, I think it depends on the age and the circumstances, and is the deputy alluding, for example, to vaccinations, or is it another area, sir?
Well, I think it's a question of general application, Chief Minister. It's not normally a process of getting the questioner to drill down and specify exactly what they're getting to. So are you able to answer it on the terms that it's posed?
I think that's getting fairly well out of my remit, sir. As a principle, sir, I do think parents should have an understanding of medical issues involving, and by children, sir, I do mean children.
Supplemental,
Yes, please, sir. And Chief Minister, correct, I am alluding to vaccinations. And is the Chief Minister comfortable that it is the case right now that 12-year-olds can present themselves to the vaccination centre without their parents and gain a vaccination without the consent of their parents? Thank you, sir.
Right, short answer, so the deputy's wrong. As I understand it, and certainly that's what I've been briefed, sir, and I believe is what also has been put out in the public domain, is that, for example, a 12-year-old cannot present themselves to the vaccination centre without the permission, without having parental consent, sir.
Sir, I believe the Chief Minister may want to check facts on that, please.
Well, that's a matter for the Chief Minister, Deputy, of course. Deputy Pamplin.
Thank you, sir. Will the Chief Minister be able to update the Assembly on my amendment to last year's government plan, which, if for his and the public's knowledge, was funding for Statistics Jersey for additional work and surveys on the issue of poverty and relative poverty to contribute towards this year's island plan, government plan to develop a poverty strategy? Thank you, sir.
Yeah. Sir, from my recollection, and I can't lay my hand on the page reference, but I shall do my best to, is that there is funding in the plan, which then will allow that poverty strategy to be developed. So an action point has arisen from the deputy's proposition.
Supplementary. Yes,
sir. Will the Chief Minister be able to, at some stage, to myself and I'm sure other states members, presentation of the work that came out of my amendment, which included, and so we could see those additional surveys, and when would they be available? Because there's, I'm sure, it'll be very useful to a lot of things coming down the pipeline this year. Thank you, sir.
Sir, I will also go and refer back to the exact wording of the amendment and the proposition. So my understanding, my recollection, but I'm happy to be corrected, sir, is that it was very much about getting funding into the government plan, which is certainly what's been done. But I'll find out, sir, in terms of where we are, in terms of the work towards developing a poverty strategy, sir.
Well, Deputy Tadia.
Thanks, sir. The question relates to the discussions that are being had in wider society about assisted dying. And does the Chief Minister accept that it is for each individual to choose how and when they die?
So I think the assisted dying topic is going, when we get to that, that debate is going to be a very difficult and very emotional debate. I think, so whilst one can, without commenting on it from a personal perspective in any shape or form, and so there shouldn't be interpreted one way or the other, one's got to be slightly careful between the individual, sorry, so I'm getting an echo, an individual versus the wider societal consequences. And I think that's probably all I need to say at this stage, sir.
Did you want a supplementary, Deputy Tadier?
I do, sir, because I think, of course, whatever legislation is brought about, anything will depend on detail. But as a principle, I think it would be helpful to know what the Chief Minister, the leader of government, thinks on the issue, and whether he accepts that it's acceptable, it's right that an individual can choose to take his or her life if and when he or she wants to.
So just to be very, very clear, any individual views about assisted dying, the debate, sir, is not going to come from a government position. As far as I'm concerned, sir, it is going to be very much every individual coming to their particular view on this matter. And therefore, so what I was trying, I think, to allude to, which I think is one of the considerations, is that for an individual's perspective, and having control over their own personal circumstances is obviously one side of the argument. And the other side of the argument from the societal perspective is making sure, particularly aimed at elderly, that elderly people are not suddenly felt unwanted and therefore influenced, individuals then becoming influenced into making, if you like, an individual decision, but mainly from pressure from society rather than because of their own individual circumstances. But I will just say it is absolutely so going to be a matter of conscience, if that's the right expression, a matter of an individual vote for all members when that debate comes.
Time for final question, Senator Moore.
Thank you, sir. Could the Minister, Chief Minister, describe the reasons for an appointments commissioner to resign during the appointment process for the new chief executive, and then could the Chief Minister further explain to the Assembly why he thought it appropriate to extend the tenure of the current chair of the Appointments Commission?
Well, so as for the latter, I think that's laid out in the report that's been circulated to, has been laid before the Assembly, in terms of the extension of that particular term. And obviously, so the Appointments Commission is independent, so I'm not aware of the circumstances surrounding the resignation.
Well, in fact, that does bring the time available for questions to the Chief Minister to an end, and that formally closes question period. We now move on to public business. The first item of public business, well, before we deal with the first item of public business, a decision needs to be made about whether or not the Assembly is prepared to reduce the minimum lodging period in respect of one of the items listed on the order paper. The item is the amendment of the Minister for Infrastructure of the Draft Road Traffic number 68 Jersey Regulations, P39. Minister, do you wish to make the proposition under Standing Order 26.7 that the lodging period be reduced to allow this matter to be debated at this sitting?
Indeed, sir. Obviously, this has gone through in the first reading. The amendment was suggested and with comments from scrutiny, and I would be obliged, sir, if members would accept this.
Well,
Seconded, sir.
The proposition is seconded. Does any member wish to speak on the proposition to reduce the lodging period? If no member wishes to speak, then I will take this on a standing vote unless anyone indicates in the chat they would wish the appel. So, Deputy Tadier, is that a request for the appel or just a request to?
I think
recorded vote. But yes, very well. Very well. The appel is called for. I ask the greffier to place a voting link into the chat. The vote is on whether or not to reduce the lodging period to enable the amendment to Draft Road Traffic number 68 Jersey Regulations to be debated at this sitting.
Sir, sorry to be a nuisance. I was late for the roll call, so Mr. Dunn tells me that I'm absent and I won't be allowed to vote on anything.
I think you might have been excusé. If you're excusé, then you can come back in without any further murmur. But let me just double check that. Yes, you're excusé, you can vote.
Thank you very much, sir.
Very well, the link is in the chat. I ask the greffier to open the voting and I ask members to vote in the normal way.
Going to be a pain again, sir. I haven't got the equipment.
Well, I will give that the most liberal interpretation, and if you'd like to indicate your vote, pour.
Oh, please, sir. Thank you very much.
Members have had the opportunity of casting their votes. Ask the referee to close the voting. The proposition has been adopted. In the link, 41 votes pour, no votes contre, no abstentions, with a further 4 votes noted in the chat and in the assembly. Voted pour. Very well. The proposition is adopted. We will deal with that matter at the time that we deal with the next item of public business. The first item is the draft road traffic number 68 Jersey regulations, lodged by the Minister for Infrastructure. For the purpose of the debate, the main respondent will be the chair of the Environment, Housing and Infrastructure Scrutiny Panel. This debate resumes, as members will recall, following the adoption of the principles on the 9th of June and the referral then to the Scrutiny Panel. Minister, you've lodged an amendment which the Assembly has agreed to take today. Do you wish to propose the regulations in second reading as amended?
I do, sir. Yeah.
Very well. Do you wish to propose them now, or do you simply wish to, in other words, do you wish to speak to them?
Yes, I think I should speak to them, sir. Some of them are quite wordy, and I may need the assistance of the Attorney General in places. But, draft road traffic regulations number 68. Duty of a driver in case of accident, 52. The driver of a vehicle must comply with paragraph 2 if, owing to the presence of a vehicle on a road, an accident occurs in any of the following: personal injury to any person, damage to another vehicle or any other property, movable or immovable, including land and anything constructed on, fixed to or growing on land, or injury is caused to any horse, cattle, ass, mule, sheep, dog, goat or dog, and of course now including cat. The driver of the vehicle must stop, and if required by any person having reasonable grounds for doing so, must give the following information: the driver's name and address, and if different, the name and address of the owner of the vehicle and the registration mark of the vehicle, and whether and the extent to which there is a force in relation to the user of the vehicle, a policy of insurance in respect of third-party risk. If for any reason, including not being required by any person, the driver of the vehicle does not give the information referred to in paragraph A, the driver must A, immediately inform a police officer of the occurrence of the accident, and B, must not move the vehicle without the consent of a police officer. 4, if a driver of a motor vehicle reasonably believes that a cat has been struck owing to the presence of the vehicle on the road, the driver must stop the vehicle as soon as it's safe or reasonably practicable to do so, and B, notify a person or body described in paragraph 5 of when the cat was struck, and 2, the location where the cat was last seen by the driver. 5, a person or body for the purpose of paragraph 4 is A, a person who is responsible for the care of the cat, or B, a person or body specified for the purposes of paragraph 4 in a code issued under Article 85. 6, if a person fails to comply with paragraph 1 or 3, that person commits an offence and is liable to a fine and imprisonment for 6 months. 7, if a person fails to comply with paragraph 4, that person commits an offence and is liable to a fine of level 3 on the standard scale. 8, a person or body referred to in paragraph 5b who is notified of information under paragraph 4 must A, keep a record of when the cat was struck and when the cat was last seen, and B, make that information available to any person who seems to have reasonable grounds for acquiring the information. For the avoidance of doubt in respect of an accident injury involving to an animal, this article is without prejudice to any other action a person may take to avoid liability under Article 4, cruelty and unnecessary suffering, and Article 5, neglect and abandonment of the Animal Welfare Jersey Law 2004. So just for illustration, the fines at level 1 would be £200 fine, level 2 is 1,000, and level 3 is 10,000. I would respectfully suggest members of the public that if this goes through, then they should log into their mobile phones the JSPCA telephone number, which is 724331, so that can be rung in the event of an animal being hit. I will just make reference to the amendment, sir, just to refresh members' minds. So page 9, article 2, in paragraph 4(1), if a driver of a motor vehicle reasonably believes that a cat has been struck owing to the presence of the vehicle on the road, the driver must substitute paragraph 5. If a cat is hit by a motor vehicle whilst that vehicle is being driven on a road, the driver of the vehicle must. And 2, in subparagraph B1, or struck, substitute hit. After paragraph 4, insert, a driver is not guilty of an offence of failing to comply with paragraph 4 if the driver of the motor vehicle did not know and had no reason to suspect that a cat was hit by the motor vehicle. And obviously renumbering of subsequent paragraphs. More than happy to answer questions by members, sir. Thank you.
Are the regulations seconded as amended and in second reading?
Yes, sir.
Does any member wish to speak? Conitab of St Brelard.
Thank you, sir. I'm grateful to the Minister for his amendment, which he has submitted in response to my panel's concerns over the detail of the process of potentially bringing a charge against a miscreant. It's never easy, sir, for a layperson to understand the language of the law, but if, sir, this Assembly accepts the proposition, I would urge the Minister to insert simple language into the Highway Code and driving test syllabus to make the message clear for all to understand. So whilst I'm aware that the principles have been adopted, I have to mention my concern that the threat of a £10,000 fine and imprisonment for 6 months could be counterproductive and in effect discourage the reporting of cats being hit. The counter argument could be so that it will act as an encouragement to report. That, sir, of course, is for members to consider when voting. Thank you, sir.
Very much, Conitab. Deputy Masson.
Thank you, sir. And first of all, I'd like to begin, as I did when we were debating the principles of the law, to put on record and thank the organisers and of the petition that received over 5,000 signatures in order to bring this to the Assembly, who we are very lucky and fortunate that they have managed to be able to join us in the public gallery today. And members have expressed their gratitude for them being able to join us today. So I am grateful to the remarks of the scrutiny panel. Looking through their comments, they are largely supportive of this change to the law. They do raise some very important themes, which the Minister will consider in due course, no doubt. And I'd like to thank the scrutiny panel for allowing the Equal Rights for Cats group to be able to give them evidence, and as well as the further evidence that they managed to gather from the JSPCA, which chimes with the views of the Equal Rights for Cats group. And I'd just like to quote from the comments of the scrutiny panel from the JSPCA, where they say, sometimes owners can be searching for days before a body of a cat is discovered, not knowing is extremely stressful for the cat owner. And we believe that if accidents are reported, we can recover the body and give the family closure. Unfortunately, not everyone is passionate about animals, and we would not consider the impact on the animal or the owner, who would consider their pet as part of their family. If the requirement to report a road traffic accident of a cat is made in law, with subsequent consequences, should they not, more accidents will be reported at the time of the incident, and we believe that this could in fact save a cat's life. And I think from the very inception of this whole debate, it has been about matters of animal welfare, which has motivated the group and the petitioners in this aspect, whilst accepting that sometimes an animal will die. But if they are caught in time, there is much more that could be done in order to save the life of that animal and bring closure to the family, if that is the case. So again, on behalf of that group, another theme which they brought to the scrutiny panel was saying how actually Jersey can be very proud about the changes to this law, because they know that this particular law is being watched by other jurisdictions about how it can be implemented elsewhere in the world, because we know that this isn't just a problem that is unique to Jersey, it is something much wider afield. And so, sir, I believe that is something that Jersey can be very proud of. Sir, in response to the proposition that I brought on behalf of the Equal Rights for Cat group, which simply asked for a consultation, I'd again like to thank the Minister, officers and the law draftsmen who have gone even further than what was request made of them. They've grasped the nettle, they've brought these legislative changes forward. And whilst I think we all accept no law is ever going to be perfect, I think this is a huge step forward and something which the community will embrace thoroughly. I would just respond to the comments of the Minister and the Scrutiny Chair. The fine, I think it should be remembered that it's up to £10,000. It's not necessarily automatically going to be that. Of course, it will be for the appropriate people to look at the facts of the case and determine what is appropriate at the time. Sir, I am grateful to the Minister for the work that he has done. I'm grateful to the Scrutiny Panel, and sir, I'm very grateful to the work of the Equal Rights for Cat group, the petitioners, to show that actually engaging in democracy, engaging in the process that we have, embracing the e-petition service can change, make real change, not only for the public of this island, but for some of our furrier friends as well. So, sir, with that, I would just like to conclude there. Thank you, sir.
Very much, Deputy. Firstly, Deputy Wigginton, thank you very much for your contribution to the Greffiers Fund by way of fine. And yes, Deputy St Mary, you've got a question, please. Is that a question of the last speaker, a point of clarification, or is that you'd like to speak? Yes, well, I'll call on you then, Deputy St Mary.
Yes, thank you, sir. First, I, like everyone else, endorse the principles behind this, and I recall that it was, I think, Deputy Masson introduced something some 4 years ago, and I'm pleased it's now reaching its final stage. The one question I have, and I mentioned at the time of the early debate, was that my son was then involved in an accident involving a cat. He was very distraught. He hit a cat in the area house in the morning on the way to rowing training. Didn't know who the cat belonged to and who should he report to. I see that Article 5B refers to reporting to a person or body specified in a code issued under Article 85. In his reply, could the Minister perhaps remind me as to who that person might be in the absence of any obvious owner? Thank you.
You have, Deputy Ward, you have a question for the Attorney General?
Well, so I may do, but I may not. I've lost the part of the article that was read out. Sorry, Article 6, if a person fails to comply with paragraph 1 or 3, the person commits an offence and is liable to a fine and imprisonment for 6 months. Articles 1 and 3, there is a question coming here, sir. I promise I just have to give it some context, so it won't make any sense at all. Article 1 and 3 is about a driver must comply with if there's an accident, a cat is added to the list of animals there, and part 3 must immediately inform police officer, must not move the vehicle without consent of the police. What I want to ask the AG, sir, was at what point is it says liable for fine and 6 months imprisonment, or am I missing something in the amendment there, sir? It seems rather, it says and imprisonment for 6 months if failed to comply with 1 and 3. Is that this the general law of road traffic accidents, or is that added? Is the accident with a cat involved added to that road traffic accident? And so therefore I'm trying to check, sir, that we are not agreeing something by implication which is very draconian. I do agree that if things, I'll be voting for this. I just want to absolutely understand what the implications are. I think sometimes, sir, we don't do that, and we should.
Well, what I can say in terms of interpreting is that a fine and imprisonment doesn't mean it has to be a fine and imprisonment. It means that those sentencing options are available to a court, but it doesn't mean that they have to be read conjunctively. They can be read disjunctively, if that assists you. But perhaps in terms of the other part of your question, I've understood it is a matter for the attorney, or was that what you wanted to know?
I think you've answered it, sir, and I think we're back to the point made by the constable there about clear language when we put this out to people. It's very important, because I think it's important to clarify that before we move forward. Thank you, sir.
Well, Mr. Attorney General, do you have anything that you wish to add to the information for the assistance of the Assembly?
Yes, sir, and it is a comment both in relation to the last speaker and also in relation to the Constable of St Prelard's speech. The offence which relates to failing to report hitting a cat, it is not the offence that's in the proposed new Article 2.6. It is in fact a separate offence which is in Article 2.7. And that offence provides that the maximum penalty is a fine of level 3, which is a £10,000 fine, and that's relates to the specific offence where the driver of a motor vehicle fails to notify the JSPCA that there has been they suspect there's been a collision with a cat. The other offence is in relation to which is in Article 2.6. That relates to the wider set of circumstances which are set out in articles, proposed new Article 52.1 and 3. And that involves a wider set of circumstances, and there's a driver of a vehicle, it's not just a motor vehicle, and that's where there is damage, personal injury to a person, or damage to another vehicle or other property, or there is injuries to any of those other animals, such as horses, cattle, and so on, but not cats. So I thought I would make that distinction clear for members. I hope that's helpful, sir.
Does any other member wish to speak on the regulations as amended in second reading? No other member wishes to speak. Then I close the debate and call upon the Minister to respond.
Thank you, sir. Firstly, may I thank Deputy Masson for bringing the original proposition, Constable of St Brelod and Scrutiny Panel for scrutinising both this and helping with the amendment. The Deputy St Mary, I would just make a point that the responsible person could be the JSPCA if the owner is not in the vicinity. Just ring 724331 and they will send out, when available, an animal ambulance to locate the cat. Otherwise, with a phone call from the person driving the vehicle or even a passenger, just to state where you were when the cat was hit and an approximate location. Sometimes the animal can be saved, sometimes it is too late, but at the very least, it does give certainty to the animal owners, and you know, the animal can be rescued if at all it's possible, if the injuries are not fatal. I'm not suggesting for one moment that anybody deliberately would hit a cat, but some people do have a laissez-faire attitude, but they are in an extreme minority. Deputy Ward mentioned road traffic collisions. Clear language. I do agree with the clear language sentiments, but this is a legal document presented, so it must be in a legal language. But with regards to the highway code, absolutely we can make that as clear and simple as we possibly can. And again, I'm obliged to the Attorney General for his assistance there. And in doing so, I propose the proposition as amended in third reading.
Very well.
You can tell, please, sir.
The ballot is called for. Ask the greffier to place a voting link into the box. And ask the greffier to open the voting and members to cast their votes in the usual way.
Dear.
The laughter, I can say for those who are not reading it, is that one of the members has voted poor, as in PAW. Sorry. Members have had the opportunity of casting their votes. Ask the greffier to close the voting. The regulations as adopted have been passed in second reading. 40 votes pour, no votes contre, 1 abstention in the link, and 3 votes pour in the chat.
May I have the 1 abstention, please, sir?
Yes.
The abstention was the Deputy of St Martin.
Very well. Do you wish to deal with the matter in third reading, Minister?
Yes, please, sir.
Do you are the regulations seconded for third reading?
Yes, sir. Yes, sir.
Does any member wish to speak in third reading? Monitab of St Brelard.
Thank you, sir. I, like Deputy Masson, would like to take this opportunity to thank the Equal Rights for Cats group for their very professional presentation to the panel and to the centenniers who highlighted the issues overcharging and the process of getting to that point. We have produced a comprehensive comment paper, sir, which highlights the issues in this far from straightforward proposition, and I thank the GREP officers for their assiduity in putting that together. Thank you, sir.
Deputy St Martin.
Thank you, sir. And can I start off by apologising to members for my vote in the last vote. I got so used to pushing the abstain button for the test vote, I must have got carried away. But I just want to say my thanks also to Deputy Muscle, the Minister, and the other fellow members of my scrutiny panel. But I would just remind members, this has given me particular difficulties. I'm a great animal lover, a great cat lover. But I do wonder, sir, about the reasonably believes part of these laws, and it will become very, very difficult to get a prosecution. And I do wonder sometimes whether the time, effort and cost of trying to prosecute people when the law is so vague. But I'll leave it there. I will be supporting correctly in the third reading. Thank you, sir.
Very much. Does any other member wish to speak in third reading? No other member wishes to speak in third reading. Then I close the debate, call upon the Minister to respond.
Indeed, sir. Thank you to everyone who's spoken. As I said, thank you to Deputy Masson, Constable St Brelard and Scrutiny Panel, and the Law Officers Department who tried with all their might to simplify this as much as possible. It's been quite a long process, and everyone's done some very sterling work. At the end of the day, I work to the will of the Assembly, and with that, sir, I propose the proposition in third reading, sir. Thank you.
Help me, sir.
The appeal is called for, and I ask the referee to place a voting link into the chat. And I ask the referee to open the voting and members to cast their votes. Members have had the opportunity of casting their votes. I ask the referee to close the voting. The proposition has been adopted in third reading. 39 votes pour, no votes contre, no abstentions within the link, and a further 4 votes are counted pour in the chat. Accordingly, the regulations are adopted.
I'm obliged, sir.
Very well. The next item is the Draft Taxation, Income Tax, Goods and Services Tax and Revenues Administration Amendment, Jersey Law P51, lodged by the Minister for Treasury and Resources. For the purposes of this debate, the main respondent will be the chair of the Corporate Services Scrutiny Panel, and I ask the greffier to read the citation.
Draft Taxation, Income Tax, Goods and Services Tax and Revenue Administration Amendment, Jersey Law 2000, a law to amend the Income Tax, Jersey Law 1961, the Goods and Services Tax, Jersey Law 2007, and the Revenue Administration, Jersey Law 2019. The state subject to the sanction of Her Most Excellent Majesty and Council have adopted the following law.
Minister. Could you put your microphone on, please?
Shall I start again, sir?
Yes, I think
Thank
we
you.
didn't get too far into the...
This draft law continues our work to modernise the way in which we administer Jersey's tax system. At its core are several measures which I first lodged in the draft finance law for 2020 back in October 2019. The Corporate Services Scrutiny Panel at that time asked me not to propose these administrative measures because of the weight of work facing them in scrutinising the first government plan. I agreed not to propose them and subsequently agreed to a further deferral. Then COVID-19 intervened. I had planned to present this draft law in the sitting prior to our summer recess, but decided to defer it once again following a last-minute request from Jersey Finance Limited to engage them in further consultation. I'm delighted at last to bring these measures back before the Assembly. The most significant measures in this draft law were scrutinised by the panel earlier in 2019 and, taking feedback provided by some of their witnesses from the tax agent community, substantive additions and changes were made to them. I'm grateful for the work of the panel in formulating this draft law. I have accepted the 2 amendments proposed by the scrutiny panel, and therefore I will be proposing the draft law as amended by the scrutiny panel. Following further discussion with Jersey Finance, I myself have lodged the 3rd amendment that I believe provides the further clarity that was sought by them. I would also like to use this opportunity to commit to a review of the current tax appeals provisions. The existing processes and laws are outdated and do not reflect the reality that most appeals can be settled by agreement when the relevant information is available. Revenue Jersey has established an appeals working group with industry better to understand the current problems and to present solutions with appropriate taxpayer safeguards. In view of that, I will not be proposing Articles 13 to 15 in the second reading. These articles made some changes to the appeals process, which can now be rolled into the wider review. The key substantive measures in this draft law achieve the following. Articles 11 and 12 largely limit the power of the Comptroller of Revenue to amend a tax assessment from 5 years to 2 years in most cases. Article 28, for the first time, empowers the Commissioners of Appeal to publish their determinations where they deem that useful. As a safeguard, such publications will be anonymised to protect taxpayer confidentiality. Articles 31 to 34 extend the charging of interest to payments made late by employers under the income tax instalment system. Members will recall that I have not so far introduced the interest charging provisions for late payment of taxes, and will only do so when I am satisfied that the timing is right vis-à-vis the current economic situation. Article 37 provides a new civil power to the Comptroller to oblige taxpayers and related third parties to provide information to the Comptroller. This can be used in preference to criminal approaches in the minority of cases where taxpayers refuse to answer inquiries from Revenue Jersey voluntarily, or where a third party needs the legal cover to provide relevant information. This measure received a good degree of attention from some members of our tax agent community, and at the request of the scrutiny panel, I have provided routes of appeal against both the notice requiring taxpayers and tax agents to produce information, and also against the financial penalty for failing to comply with that notice. This effectively gives a taxpayer who does not want to provide information over 250 days to prevaricate. I have asked the Comptroller to keep this new civil power under review and to let me know if further adaptation may be necessary in the light of experience. Where appropriate, the Comptroller will continue to use criminal powers to secure information more quickly, or use criminal powers where taxpayers fail to respond to the civil approach. Various minor amendments to the interpretation and scope of the Revenue Administration Law remain unchanged from the draft 2020 Finance Law. Excuse me, sir. So, having accepted a recommendation of the CSSP report in respect of the prior year basis regulations, which we debated and passed in March, Article 20 ensures that the Assembly can in future amend those regulations. We are also taking the opportunity to make a number of corrections to the criminal provisions of our tax laws, and in particular, the 1961 Income Tax Law, to make those laws more effective than they actually are at present, or seemingly have been for quite some time. I will not mention them all here. Articles 2 to 9 remedy defects in the 1961 law, clearly to stipulate obligations to do things, for example, to file a return by a set date, to stipulate offences where obligations are not met, and or to stipulate the sanction for commission of the offence. These changes replace Article 136 of the Income Tax Law, which relates to the penalties for failure to deliver returns, and which we have concluded is simply not effective. It has rendered both the Comptroller and the Law Officers Department powerless to tackle several serious cases of non-compliance in recent years. These are therefore important changes to ensure that everyone in Jersey pays their fair share of taxes under the law. Article 24 clarifies the existing law to stipulate that the Comptroller must register a business for GST where the business has not requested it, but where the Comptroller is satisfied that the business has exceeded the statutory turnover threshold. Article 35 allows regulations to specify a period for records to be kept, other than the period required by the Revenue Administration Law. Consequently, Article 38 reinstates a 6-year period for retaining documents, which was inadvertently removed when the Revenue Administration Law was first made in 2019. So there is much yet to do to modernise Jersey's tax laws and its tax administration. This is the next modest step, hot on the heels of the conversion of all Jersey taxpayers to the current year basis of paying tax, and the work we began in this Assembly on the 15th of September to introduce independent taxation. So I ask all members to support these changes. I move the principles and call for the appel, please, sir.
Well, the appel will follow the debate, of course. Are the principles seconded?
I answer.
Senator Moore.
Thank you, sir. The Minister informed the panel of her intention to lodge this proposition earlier this year following a review of the Income Tax Jersey Law 1961, the Goods and Services Tax Jersey Law 2007 and the Revenue Administration Jersey Law 2019, which was carried out by the Treasury and Exchequer. As this proposition is considered to be a key issue for the public and linked to government strategic objectives, the Corporate Services Scrutiny Panel agreed to undertake a review. The panel was aided by an expert advisor due to the technical nature of the proposition. The panel received evidence primarily from the Fiscal Strategy Group. A public hearing was held with the Minister and culminated in the comments paper and 2 amendments which have been presented to the Assembly, and we're grateful to the Minister for her acceptance of them. In all, the panel found that the Minister is proposing generally sensible changes to a number of the island's tax laws, and the proposition goes some way in aiding progress in modernising tax legislation. I won't outline the full findings of the panel's review, and those can be found in our extensive comments paper, which I hope members have had an opportunity to review and hope they find them helpful. However, the panel would like to highlight following key points. The panel held concern that introducing the power to include individuals that are connected with an organisation, such as a body corporate, in prosecutions may lead to a conviction of the person as an individual, as well as due to their role within the organisation, risking situations of double jeopardy. This was a point somewhat missed by the Minister. However, upon reflection, the panel has chosen not to amend the proposition in this regard, as it's understood that the fairness of conviction and penalties imposed lies in the powers of the Attorney General. The panel and the Fiscal Strategy Group highlighted concerns specifically around taxpayers' right of appeal to the Minister, which would be fundamentally altered by the enactment of Articles 13 to 15 of the proposition. The panel were concerned that the intentions of Articles 13 to 15 could set a dangerous precedent of the future that the Jersey Law Commission's 2017 report on improving administrative redress has not been dealt with. Therefore, following several interactions by the panel and the Fiscal Strategy Group with the Minister of the panel is pleased to observe that the Minister has taken note of the concerns and will not be proposing draft Articles 13 to 15 in the second reading. This debate, however, has commissioned a full review of the tax appeals process by Revenue Jersey, and we look forward to learning the conclusions of the appeals working group. The panel also considered bringing forward an amendment to allow some discretion by the controller in the registration for goods and services tax. This would be particularly important if a business exceeded the registration limit temporarily or without realising it, and this was subsequently discovered by the controller at a point when the business had ceased to be required to be registered. As the wording of the proposition suggests, that he will be required to register all those in that situation. However, the panel has received advice from law drafters that this was not needed, as there is a suitable route to enable the controller to help businesses inadvertently in this position, and for which registration for a historic period would be a hardship. Once a person no longer meets the requirement to be registered, they can apply to deregister. And here the controller has some discretion on the application of the power to cancel the registration, which can be backdated if the controller considers that it's an appropriate step to take. The panel noted that the proposition makes some changes in regards to tax interest and penalty interest, although these are yet to be introduced by the Minister. The panel is pleased that the proposition will introduce the right to appeal penalty interest and asks that the Minister progresses the matter of interest both paid and received in a timely manner. The panel has identified 2 amendments needed to allow fair implementation of information notices introduced by the proposition and to aid in their future potentially digital practice. The panel is pleased to note that both of the amendments have been proposed by the Minister and members will be able to accept them in the second reading. Referring back to our comments paper, the panel has also outlined a number of areas in which the Minister must consider further in the future. Firstly, there's a need to clarify the difference between the legal requirement for individuals to keep records for 2 years and the ability of the controller to raise assessments in the event of careless action by a taxpayer for up to 4 years. And the Minister must ensure the controller provides guidance to taxpayers on this point. Secondly, the Minister must update guidance on the distinction between careless and deliberate behaviour in relation to civil penalties for incorrect returns to make the new implications of careless behaviour clear to taxpayers. And that was a point that we raised last time this law was before the Assembly. Thirdly, the panel believes the Minister must contemplate the inclusion of shadow directors in future legislation. Finally, the panel concludes that the Minister must provide the Assembly with clarity on the timetable for the review of taxpayers' appeals process by Revenue Jersey, and the Minister should ensure that the panel is kept informed of the outcome of the workshops with the Fiscal Strategy Group. The panel would like to thank its advisor and members of the Fiscal Strategy Group for the evidence which it has provided to the panel to inform its review. The panel would also like to thank Revenue Jersey team and the Minister for providing additional information to inform its review. The panel finally wishes to highlight that tax law must continue to be low, broad, simple and fair overall. This proposition does achieve a balance between the needs of the government and the taxpayer. However, as highlighted in our comments paper, there are some areas where suitable discretion is required and the fairness of appeals will be a deciding factor. The panel will continue to scrutinise the impacts of this legislation if it's adopted. Thank you.
Does any other member wish to speak on the principles? No other member wishes to speak on the principles? Then I close the debate and call upon the Minister to respond.
Thank you, sir, and I thank the Chair of the Corporate Services Scrutiny Panel for her remarks. There has been a lot of consultation and a lot of briefings over the past couple of years, and on the concerns that the panel advised us about, we have removed the articles as discussed. Just in answer to a couple of questions that the Chair's just mentioned, the criminal sanction, and Revenue Jersey are working very, very hard to support taxpayers comply with their tax obligations, but there still remains a small number of quite alarming cases of persistent non-compliance, and some involve many years of flouting the rules. And despite the civil sanctions, those few citizens steadfastly fail to meet their obligations. The Attorney General has always been willing to prosecute in these circumstances, but has found he is unable to do so because of the flaws in the legislation. So hopefully that will be changed. And the other major question was the charging of interest. When the interest provisions were originally drafted, they omitted to include employers who are required to deduct tax from their employees and send the money to Revenue Jersey. It's only right that employers should pay interest on late payments in the same way other taxpayers are required to do. most employers pay on time and have nothing to worry about. So on that, I hope I've answered the two major questions of the chair, and I propose the principles.
Well,
And call for the appel the second time, sir.
Indeed. Yes, I ask the referee to add a voting link to the chat. I ask the referee to open the voting and members to cast their votes in the normal way. Members have the opportunity of casting their votes. Ask the referee to close the voting. Principles have been adopted. 39 votes pour, no votes contre, no abstention in the link, and a further 4 votes noted pour in the chat and 1 on the floor of the Assembly. I assume your scrutiny panel doesn't wish to call the matter in, Senator? Very well. Minister, there have been 3 amendments lodged, one by you to Articles 12 and 34, and 2 by the Corporate Services Scrutiny Panel, both to Article 34. I understood you to say you were accepting the amendments of the Scrutiny Panel?
Yes, thank you, sir.
How do you wish to deal with the articles in second reading then?
As I mentioned in my speech, sir, I do not intend to propose Articles 13 to 15. Therefore, I wish to propose the articles en bloc, other than Articles 13, 14 and 15, sir.
Very well. Are those articles seconded?
Yes, sir. Yeah.
Does any member wish to speak on any of the articles other than 13 to 15 which are not being proposed? Deputy Ward.
So it's just a very quick question. In the removal of 13 to 15, does that mean it removes the ability for the comptroller on Auditor General to refuse an appeal, or just in some circumstances? Thank you, sir.
Any other member wish to speak in second reading? No other member wishes to speak in second reading? Then I close the debate and call upon the Minister to respond.
Thank you, sir, and thank you to the Deputy. I think that completely depends on the circumstances of the appeal, because you've got commissioners for tax appeal rather than the Comptroller and Auditor General, and then, of course, the AG if required. Thank you.
Well, in which case, ask the greffier to place a voting link into the chat. The vote is on the articles in second reading, with the exception of Articles 13, 14 and 15, which are not being moved. Ask the greffier to open the voting and members to vote in the normal way. If members have had the opportunity of casting their votes, I ask the greffier to close the voting. The articles have been adopted in second reading, 38 votes pour, no votes contre, no abstentions in the link, and a further 7 votes either in the chat or in the assembly voting pour. Very well. Do you wish to propose the article or the law in third reading, Minister?
Yes, please, sir. And also like to take the opportunity to thank members today for their support in uplifting our tax situation. Particularly the team at Revenue Jersey, who have had a lot of work on tax, and of course the Corporate Services Scrutiny Panel for their input and advice. And I propose it in the third reading, sir. Thank you.
Is it seconded for third reading?
Yes.
Does any member wish to speak in third reading? No member wishes to speak in third reading. Then I close the debate and I ask the greffier to place a vote into the link. And ask the greffier to open the voting and members to vote in the normal way. Members have had the opportunity of casting their votes. I ask the greffier to close the voting. The law has been adopted in third reading, 43 votes pour, no votes contre, no abstention in the link. A further 2 votes pour noted in the chat, and the Connétable St Saviour indicating a vote pour on the floor of the Assembly. Very well. The next item is the Planning and Building Amendment number 8, Jersey Law, P76, lodged by the Minister for the Environment. For the purposes of this debate, the main respondent is the Chair of the Environment, Housing and Infrastructure Scrutiny Panel, and I ask the greffier to read the citation.
Draft Planning and Building Amendment number 8, Jersey Law 2000, a law to amend further the Planning and Building Jersey Law 2002. The state, subject to the sanction of More Excellency Majesty and Council, have adopted the following law.
Minister.
Thank you, sir. Would you like me to stand?
If you...
Is it easier to sit? Sorry, if it's easier.
Whichever is easiest for you. I think in these circumstances, some people are speaking from standing, some people from sitting, but if you're using a computer, I think it's okay to do either.
Okay to sit.
Sit if you...
Okay, thank you, sir. Sir, I think the Planning and Building Law 2002 is, I believe, one of the most important laws that affects just about everybody in the community. It was introduced in 2002, and this will be, I'm proposing today, what will be, if members agree, the 8th amendment to that primary law. A huge amount of transactions and business is conducted on that law every day, and I believe that this law and its predecessor, which was the Island Planning Jersey Law 1964, I believe has largely been responsible for the island remaining relatively unspoilt, and we manage what is a finite land area. And of course, this law does interfere with the private rights of people in their land and property. And in fact, we've got the benefit of a really, and I'm grateful for the Law Office and the Attorney General and the report on the human rights issues in the report, and therefore judgments have to be made of how far one goes in the law. This today is an updating with some significant changes in it, which I'm going to focus on. And of course, you know, why do we have this law? It's to regulate change in the built and natural environment, and it provides the means of protecting, enhancing, conserving, and wise use of our natural resources and the biodiversity of Jersey, and also to improve its amenities. And of course, one of the key phrases that I often recall, the law is there to ensure that land is used in the best interests of the community of Jersey. And that's a really important principle. So today it's there are 20 individual amendments. This is something that myself and Deputy Gieler have worked on with the officers throughout our term, and I'm very pleased that we've been able to bring it through. It's complex, and that is why it's taken a lot of time. 10 of the changes are minor changes, and what they are basically seek to do is to reflect what is the current practice and the way we work, because obviously a lot of things have changed, systems and processes and so on. And in fact, the world has changed since that law was enacted in 2006. Actually, the law actually commenced, went into being. 7 are minor changes that have arisen from case law, appeals, very significant applications, or other situations from which their learning has taken place. And then where I get to the real issue is that there, in my view, 3 of the amendments are very significant. And I think I'd be surprised if they're not the focus of today's debate. And I'm happy to, of course, deal with members' queries about those 17 other amendments. They're in the proposition, they're explained very clearly, and I'm very pleased that the report kind of sets out, if you like, groups the explanations in the nature and purpose of the law changes. But the 3 main amendments, the first one is the introduction of a power in the law to have areas of the island designated conservation areas. And this will be where there are special characteristics. It says conservation in any area in Jersey to which there attaches a special architectural or historical interest for the purpose of protecting and improving the character or appearance of that area. I think we all know where those places might be if this is passed into law. It's not a new concept. It has in fact been in successive island plans for decades, is that we would have a power to declare or agree conservation areas, but that has not been possible because there's been no power in the law. And of course, it requires a primary law change to do that. I think it's true to say that Jersey is behind other places. We are signed up to international conventions, I think, and I think those conventions require us to recognise and respect and look after our heritage. And I think very much that is a theme of the times. And so that commitment is still strongly in the draft island plan that's out for in its final stages before it comes to this assembly early next year. And that gives some guidance of where those areas might be. But of course, there is a huge amount of detail that would have to follow here to put that into practice. And that would require what the draft law requires, detailed regulations. So it's an enabling power in the draft law, which if you approve, then at a later date, at some stage, will come back detailed regulations, which will set out the way the conservation areas will be identified, defined, and the processes that take place, and what the likely implications would be for landowners and property owners in that area. As long as I've been involved with land use matters, I'm aware that there are communities in Jersey which strongly favour that. And I think it's an open secret that one of those is St Aubin. Obviously, where those boundaries are, it would be to be discussed and consulted on and worked on once we have, we have the regulations. Because drawing those boundaries and it's not easy. But I have heard it said, and I think that we have to do this because otherwise the nature of some of these areas, these special areas, will change forever and the special character will be lost. So that's an enabling power. The second one is about the procedure for determining what's called a call-in planning applications. Members will of course know is that planning applications, the majority are decided by the planning panel, the planning committee, and also planning officers. There's delegations in place. Those are the principal deciders, first decision makers, if you like, of planning applications, making quasi-judicial decisions. But there are some applications where the minister has power to what's called call it in for a public inquiry, where there's a number of circumstances where the minister considers is that this is a matter where there is a large amount of public interest and that the application raises issues which affect potentially a large proportion of our community, and or indeed propose things that are not in line with policy or maybe guidance and so on. And those are legal powers that exist. And my predecessors in those roles have used those powers. I think they've been used wisely. I've used myself and powers on a number of occasions. It's something that one doesn't do routinely because it's expensive, but nonetheless it allows for a proper public hearing. But the issue has always been with such a process, who makes the decision? And the law as it was introduced back in 2006 puts that responsibility solely on the minister. The minister, it says the decision can only be made by the minister. That's the current law. And of course, there has been lots of debates about, is it right that you have a political decision on a planning planning application after it goes to an inquiry? And successive processes of review by legal experts and others, and this assembly has determined it needs to be a democratically elected person who makes that decision. Now, I've formed the view that I think there is merit to giving the person who is in that position. And of course, this is a change for the future. The person who ends up in that role, whether they can to have them the option of either determining the application themselves or invoking a panel of the minister, an assistant minister for the environment, and the chair of the planning committee. And I think that there are potential significant advantages in that. Over my years working in this type of area, I think there is, I believe, always merit in having really difficult decisions where there are a lot of complexities just shared by a group of individuals, not by a large group. I mean, obviously, we have this assembly. I've never thought this assembly is the right body to determine planning applications, but a small number, a group of 3, I think is pretty well ideal. So that's quite a significant change. And it really is up to members whether they think I'm right to bring that change. And the third and final amendment is a very significant and one important to many people in the island, which is about introducing powers for the planning system to manage manage how we look after our trees in the island. Trees play a huge part in our lives. They are hugely important in biodiversity. And biodiversity, again, we're committed by international conventions and to exercise good stewardship and look after our natural environment, but also, of course, climate change. Climate change, trees, we all know, fix carbon, really important in ecosystems. And of course, I believe that they also add to well-being in people. They enhance the quality of people's life. And I think anybody who had doubt about that, I think would have realized, noticed during a lockdown when we had exercise, how a joy it was to get out into the fresh air and enjoy those trees. And of course, what do our young people tell us? Only I noticed today in the Jersey Evening Post, there was a school group in St. Lawrence, and it was music to my ears, where the young people say, we must do better. But of course, the issue is how are we going to do that? And again, the approach being taken here is to put in place an enabling power in the primary law, so that in the future, we can have this subordinate legislation that tells us how we do that. And of course, that is something that work is in progress now through a tree strategy, which was set in place. That I think members had a briefing of that recently from the team doing that work. And that was work which principally the Environmental Scrutiny Panel enabled us to do. And I'm very, very grateful of their support and the funding they gave us for that. And so, obviously, one of the things that one wants to do is to have a way in which we can recognise that the tree cover, landscaping is as equal part of development as anything else. And we need to be able to ensure that we get that cooperating in a symbiotic and respectful relationship with our buildings. Now, it doesn't mean to say, I ask members to say, this isn't about protecting every tree. Choices are going to be necessary. What type of trees are important? Where are they? At the moment, the system that we have in the planning law is completely inadequate. And all of the evidence that we've been able to look at shows that it's not been successful in protecting the very best of our trees. So I think I just wanted to introduce that, and I expect there will be strong opinions from members, perhaps either way. But I do ask for members' support on that. Trying to find my lost page. I think I've lost a page here, which is a shame. Never mind. To cope with that. So I think that's what I'd like to say to start with, but I will respond to members' questions on the other matters, probably go in as well. So I therefore make the proposition, sir.
Well, is the proposition seconded?
Yes, sir.
Conataba Simbrilla.
Thank you, sir. I would ask the Conataba Gruville to act as rapporteur for the panel.
Conataba Gruville.
So before I speak, I'd like to refer this matter back under Article 83 of Standing Orders. I'm not quite sure how do I make that proposition and give the reasons why I'd like to do that.
Yes, Standing Order provides that once the debate is open, and it is now open because it's been proposed and seconded, any member may propose without notice on a proposition. The proposition should be referred back in order that further information relating to the proposition can be provided, or any ambiguity or inconsistency in information relating to the proposition which has already been provided to the states be clarified. So it's open to you, Conatab, to move the proposition for a reference back, but to explain precisely what it is under those two headings, either the ambiguity or inconsistency or the further information you require before the matter that can be dealt with. And that will be a part of your proposition. There then follows, if that is seconded, a debate purely on the question of the reference back before we then, if it's successful, it's referred back. If it is not successful, then we proceed with the debate, and you'll be asked to continue with your speech at that point.
Thank you.
Does that assist?
Indeed, sir.
Very well.
I must say this minister usually, over the last 3.5 years, has always taken our scrutiny panel with him, as has his officers. They've always engaged with us early over matters, but this particular item somehow or other got under the radar and came to us. Well, it was lodged at the beginning of August, which is, and I'm sure there was no intent on his part, but it's not a good time to look something to be lodged because people are on holiday, whether it's scrutiny panel members or members of the public who take an interest in these things. And so we don't think proper consultation has taken place over this matter, but of course consultation is not necessarily a reason why we should not debate it. But there is a list of information which we think, or I think, is missing, and I think our panel agrees with me. There's no detail provided within the proposition as to what the likely impact on resources the introduction of the tree control change might have for government in terms of the planning application, permissions and appeals process. There's also no detail provided in relation to how the administration and enforcement of the proposed conservation area change will be resourced. It's widely known that the IHE department is under-resourced in many areas, particularly within environment and planning. The Minister has acknowledged this himself. However, there is no mention in P76 of the impact the proposed changes are likely to have on the departmental budget and the manpower resources in general. There's no detail on how the 3 major changes proposed will be implemented, including governance procedures, clearly setting out roles and responsibility for government in implementing the proposed changes. The outcome of the tree strategy and associated consultation is unknown, and therefore the detail is missing from P76, which may or may not strengthen the rationale for the proposition. Similarly, the designation of conservation areas is to be addressed in the proposed Bridging Island plan. The outcome of this policy process is still unknown until the states agree this in the final plan earlier next year. There's no detail provided around the governance there will be around the proposed determining panel and how this will aid and not hinder the planning consent process, and what additional resources the administration of this may entail. I therefore suggest to members that we should refer this back to give members of the public and our panel more time to consider these proposals. Thank you, sir.
Very well. Is the proposition for a reference back seconded?
Yes, sir.
Does any member wish to speak on the question of a reference back?
Sir, if I may.
Sorry, nobody's indicating in the chat. Is it? We don't indicate by lights. We indicate in the chat so that every member has the chance of. Yes, and you did, Deputy. I apologise. Deputy Basson.
The system is just thinking about it. Thank you, sir. It's just more an opportunity to hear from the Minister or the ministerial team just to explain what engagement was had with the scrutiny panel over this particular matter in order for us to make a decision on this matter, as I'm sure they would have been briefed along the way. And of course, they do have call-in powers afterwards as well. Thank you, sir.
Deputy Guida.
Yes, sir. Sorry. Oh, it says cute. Can you hear me?
Yes, we can hear you, Deputy.
Sorry. Yes, I would just want to note that this legislation sorry, there is actually quite a hurry to get this legislation voted. And those also that the main amendments are enabling. Sorry, yes, the main three amendments that we've talked about are mostly enabling amendments. So the one that says that you can have a panel of people deciding an inquiry is optional. It's something that the minister can do. It's the same with special areas. It is also something that is completely optional, and of course that can only be developed with consultation from everybody involved. The last one, and that is quite important, the tree law again is just making work on trees development that is subject to planning application, and this is withheld until we have an order determining exactly what sort of work and what sort of trees. This is actually quite urgent because as of today, this is now public knowledge. It is known that we will introduce tree protection, and there will be a race to cut down all the trees that are even vaguely annoying to anybody. So if we want to protect trees in Jersey, it is something that we have to do quite in a hurry. The order is being readied through consultations with the public, so it's something that will have had the agreement of everybody involved, of a very wide range of people, but it is important that it is done as a matter of urgency now that we've started the process. Thank you, sir.
Thank you very much. Deputy Doublé.
Thank you, sir. I wonder if it's possible to elaborate on the information that the panel are asking, because there's specific consultation I'd like to see. So I just wanted to add and it's about the articles that are relevant for tree protection. And when I was reading this, I mean, obviously I can understand the wording, but it's as I think as Assembly members, we need to understand the implications in a bit more detail than is contained in the report. So I personally would like to see that consultation has been carried out with Jersey Trees for Life in particular, and I'd like to see their views. I mean, preferably from the minister, but via the scrutiny panel if they have more time to do that and issue comments, because I think it's important that we understand whether the proposed protections go far enough, because it's an important issue, tree protection, one that several members, myself included, in the Assembly are really passionate about, and we want to get it right. And I don't accept the previous speaker's argument, because the tree protection, my understanding is that it will be attached to an order anyway, which is going to come after this legislation. So people who are going to carry out such actions, as the previous speaker is alluding to, will have a chance to do that anyway. So I don't accept that argument, and I'll be voting in favour of the reference back.
Very much. Deputy Wickenden.
Thank you, sir. Obviously, I agree tree protection is something that we have been waiting for properly to be coming in, and I look forward to actually that happening. On the reference back, sir, obviously the scrutiny panel themselves have called for the reference back. If that's done, they still have, or if it fails, they still have the power to call it in as scrutiny can, and nobody can stop a scrutiny panel from calling in legislation to be looked at. My concern is that we do have a need to start doing protection on trees. We've seen too many developments in the past taking down trees that have had a real detriment to this island. And I want the proposer of the reference back to give some confidence that if they work with the minister on this reference back, if it's passed, that then after we come back again, that it won't suddenly be called in by scrutiny on second reading. And I would like some kind of confirmation that we're not just going to go further and further down the line on this, because it's too important a matter for this island, sir.
Colin Tarver, St Mary.
Thank you, sir. I don't like the wording of the article when it says the introduction of control over any felling, lopping, pruning, and any alteration of any tree. Lopping, pruning, is essential in order to protect trees, regardless of a preservation order. A felling order is totally different. The word any alteration of any tree leaves this open to change. Jersey has more trees at the moment than at any time in recent history. People realise that trees are important and have made great efforts to address this by numerous planting right throughout the island. Lots of land is now used for orchards. People do respect trees, but they do have to be kept, regardless of a preservation order or not. This law could seriously jeopardise a lot of gardeners and tree fellers and tree surgeons, and could make their life really difficult. I think a reference back is vital. Thank you, sir.
Very much. Deputy Labby.
Thank you, sir. And at least the Constable of St Mary has put his objections out there in terms of the implications of the legislation on gardeners and anyone with a tree. And that's fair enough. But I think, picking up on Deputy Wickerton's, I think to reference back this on issues of resourcing is slightly weird when the panel has the ability to call it in after the principles have been agreed. And the principles here are very simple, and I applaud Deputy Young with all that he's got and his office have got with their workload with the Bridging Island Plan to have brought this in, and brought this in speedily, because we are way behind on a lot of these issues. We have always been in Jersey way behind on the protection of the built environment, the historic built environment. We've got better, but surely the principle of keeping characterful areas of Jersey characterful and unspoilt, and little protections for those areas of character, surely that is a principle that we could all agree on. Similarly, and chiming in with the public feel this way too, we can all agree that we want to do something to protect big, mature, majestic trees from indiscriminate felling. And surely we also want to see the continuation. Our planning system's got so much better than it was. Do you remember the days we used to open the Evening Post in the 70s, 80s, even the 90s, alas, and read about another planning disaster, an eyesore, something being demolished. And planning has got so much better. And one of the architects of that was Deputy Young with the planning system we have now. And all he's trying to do with it is to make it even more fairer to both sides and transparent and open. And actually, when it gets to the stage where it goes to the minister, having it been open, transparent and fair to both sides from the moment the application goes live to the end of an appeal, once it goes to the minister, that section then suddenly goes back behind closed doors, because actually we don't see the minister and his deliberation. We don't see who he takes advice from on it in either side. So he's trying to correct that too. So those are three principles I think the Assembly can all agree on. If and I respect enormously the scrutiny panel, who I enjoy working with as a minister, my panel too. I think that the thing to do is let us agree these principles and then by all means call it in. Thank you, sir.
Very much. Senator Ferguson.
Yes, sir. Sorry about that. Where are we? Yep. I'm terribly concerned about the tree side and the rather dictatorial approach that's being taken. You know, if you've got two neighbours and there is a covenant on the height of hedges between the neighbours, are you going to just say that they can't lop the trees that comprise the hedges? And a lot of the trees that people get terribly emotional about. I mean, I'm all in favour of trees and so on, and proper looking after them. But you know, there are a lot of things like home oaks in the island, which they're weeds. Sycamores, they're weeds. And, you know, if you let the sycamores just carry on growing, they'll just get so crowded that they'll kill each other off. You know, I think we do need to look very carefully at this. And the other thing is, you talk about it's, you know, unnecessary to look at resources. Well, I don't think planning have got the resources to review landscape plans, let alone follow up every little tree argument. So, no, I think we ought to refer it back so that the panel can actually look at the things that bother the public. Thank you.
Thank you, Senator. Deputy St Martin.
Thank you, sir. And I'd like to just take members back to the reason and the debate we're having here, which is a reference back. It's not on the principles of the Minister's proposals. So one thing I'd just like to focus on is the financial statement which comes at the end of the Minister's report, which says there are no new financial and manpower implications for the states arising on the adoption of this draft law. And so I sit on the scrutiny panel, but I can't remember where or when it was, but I have heard the Minister say that he's hoping very much to have 5 new employees in an office dealing with applications to deal with the tree legislation as proposed here. And I find it very difficult to see how he can make a statement that says there's no new financial and manpower implications, when at the other hand he's saying he's going to employ more people to deal with the applications to fell trees. So I think that alone is a good enough reason to refer this back. Thank you, sir.
Very much. Does any other member wish to speak on the question of a reference back? Minister.
Thank you very much, sir. Well, I'm a bit surprised, to say the least. For me, this law contains 3 significant changes, and the rest of it are important changes which are uncontroversial in my view, really important and necessary changes. And what a shame to propose, well, there's some questions here we want answered. Kick it out, let's just shut our mind to the lot. The way to deal with this, frankly, I think there's the opportunity for amendment, and there is the call-in procedure, which was available. So what I've heard today, I thought, you know, I didn't expect this. I'm surprised and disappointed because, contrary to what's been said, I've certainly arranged for briefing notes, but just stick to the big picture for a minute before I pick the particular points about trees. You know, the routine amendments here are about procedure changes for people's appeals that the judicial graph, the planning officers, those that administer it have asked for, corrections in processes. So we're going to lose those, or we're going to, you know, where's that going to go? There is a time issue there. We need to do this. You don't get the chance to change primary law very frequently. There's that. There is measures in here to allow us to deal with things that people are crying out for, like electric vehicle charging points and so on. And, you know, that kind of infrastructure at the moment, we don't have the rules for. So, okay, so we're going to treat that in the same way, are we? That we got processes here. This is, and of course, the big thing is that I spoke about there are safeguards all over this. First of all, there is regulation. Nothing can happen until regulations are brought. Regulations would have to be lodged, they'd have to go through the panel, there'd have to be consultation, more consultation, because it's not true to say there's been none. This is our changes in principle, and they would not come into effect until after those regulations have been approved by this Assembly, including the detailed content, answering all those questions on conservation areas. And also, I insisted on this, there would be an appointed day act provision. That means this law change would not come into legal effect until the state specifically pass an appointed day act. That's not often the case. It's done here because it's recognised that there are significant things that need to be done. I am disappointed, sir. The reason why we have concentrated on trees is not just for the reasons that Deputy Gita and myself spoke of, but of course the scrutiny panel have always been very, very keen on this. And in fact, the scrutiny panel brought an amendment to the government plan to enable this tree strategy work that's happening now. The panel have had a briefing that we've engaged people to work with who do this kind of consultation work. Frankly, I was trying to find the presentation. It's been circulated around. You know, I can't remember how many members turned up to it, but they've had that presentation. And that involves all these people, the tree surgeons, the groups, what used to called Men of the Trees, I think the Trees for Life now, all those groups. Now, the feedback I've had from that workshops they've been holding, they've held several, is that they agree with the principle, but there is detail to be discussed. Look, we're not going to protect every tree. That's ridiculous. Absolute nonsense. We're not going to stop round, you know, lopping and so on like that. We have a thing called permitted development. The way the law works is you put the power in the law, and then you pass a subordinate legislation to be able to say what can be done without having to make application. And that will be, I would say, 99% would be dealt with in that way. It'd be madness to do anything else. So I think your members, please, you know, what people fear is a big brother here. And why does it say there are no resources? Because there are no resources until it's implemented. Now, I personally don't. I think there's so much work to do here that I think it's going to take quite a time. My officers tell me they think they could get this work done before the end of the term of office of this Council of Ministers. I'm not so sure, personally. There's a lot of work here, and at that time they're resourcing it. But of course, one of the strengths we've had, and I've been a critic of the target operating model and the chief executive changes, but I'm told by the officers that those changes have freed up, and the reshaping of responsibilities between different parts of the IHE structure will allow those works, will allow us to do what is a reasonable level without excessive manpower costs within the resources we have. Yes, I'd like more. Yes, there's fortunately there's a very modest amount in the government plan. We can do that. But what one does have to do is to set the direction of travel, and this is what this law does. So I think the proper thing to have been done was either bring in amendments or call it in. And then we can have a discussion about the detail on those particular points. But to lose the whole lot on some kind of blanket situation, I think, frankly, is not the way this assembly should do it. I mean, there are all sorts of options of what can do about trees. The last thing I've got in my head is applications. We had the same situation when planning took over the control, or at least a planning control on electrical work. What you do is you have systems of notification. You work with the electricians and the bodies, and you work up standards. Standards that mean you don't need applications, but you are regulating it. You provide in a measure of control, because what we don't want to do is to lose the very, very best of trees. And there have been situations where, you know, trees that are, you know, many times my lifetime are then, people get really upset when we lose those. The law is not enough at the moment, so this is an enabling power. So I ask members, please, don't support this. Yes, when we get to the articles, yes, then, you know, if the scrutiny panel want to call this in, I'm not going to be objecting to that, because we can do that detail work. And by then, you know, then the questions that are being proposed by the Conitard of Greville and shared by his colleagues, we can answer them in detail. But please, allow us to make progress. Conservation areas particularly. Are we going to repeat the situation on conservation areas where the last 3 island plans have had a planning policy on the heritage that we've not been able to do anything about and ignore? Are we going to do that really? No. Put it in the law. So look, I'm going to vote, please do not support this reference back.
We give way for point of clarification from the Conotab of St John.
Yes, sir. Of course I will.
Thank you, sir. I'm just slightly confused. The Assistant Minister said it was urgent, and the Minister has told us that nothing will happen in a hurry. Can we clarify which is correct?
Well, we've got our own opinions on that. I think that there is no question that looking after trees and biodiversity is an urgent commitment. It is an urgent commitment. We are losing biodiversity. We are going out on climate change with a new set of policies. Carbon fixing is really important. I was being realistic about how I can implement what is a very, very big challenge in planning law in a short timetable. Now, my office, as I said, and I did qualify it, sir, for the constable's benefit, my officers are telling me we can get this done, probably get the draft regulations done by the end of the year, so they could come forward. I'll be honest, sir, I don't want to promise that if I can't deliver it. I want to make sure that those are robust and they are practical. I want to make sure that. So that's why I'm being a little bit more reserved and saying, I think the best one can achieve is by the end of this term. For me, members will probably know, this is a personal thing, this is for me about the future. This is to make sure that whoever ends up in the ministerial jobs has got the ability and to do things that this community cries out for. So please don't.
I think this has gone a bit further than a clarification of your,
apologies, sir.
your speech. Well, does any other member wish to speak? Deputy Ward.
Thank you, sir. It's a difficult one, this.
Oh, I beg your pardon. Yes, sorry.
Oh.
No, you're quite right. I was confusing myself. No need to trouble you with why. Deputy Ward.
Thank you, sir. I've confused myself now. This is a difficult one because a reference back is not something I'm familiar with, and I sort of understand that the point of that. However, I must ask, and I will talk about the reference back, not the main proposition, because this is about the reference back, and I think sometimes we do lurch into other areas when we have a reference back, and we need to really focus on what we're saying. So what I would like to know is, I suppose the most important thing I'd like to know is what will be achieved by referencing this back? Because there is obviously an urgency, and I am very pro legislation and regulation to protect areas of our environment on this small island. It is really necessary. We are living in a changing world, and there are changing pressures, particularly with population and housing. And we need to be very careful about our environmental impact. And so I see in these regulations some very positive things. So therefore, I ask, what will be achieved by referencing back that will improve these regulations? One of the things that was mentioned was the notion of resourcing. By referencing back, and I asked the constable who wants to reference back, these are genuine questions. This is not about, this is about debate. Are you suggesting that one of the issues is resourcing of the Environment Department? So therefore, what we need to do is increase that resourcing so we can actually get things done. Because I think it's a great idea. On a personal note, we may have a landlord licensing law if that was the case, because that was one of the arguments used against it. So if we're saying about resourcing, then great. But that needs to be made clear. Is there something else behind this? Is this a general principle of not wanting regulations to be enforced by government over environment? Because if it is, I don't think that is the place for a reference back. That's a place for just for voting against this, full stop. When we reference this back, so we will take it away, and nothing will happen necessarily unless we are very, very clear as to what happens, what the reference back wants. I've got to explain this carefully. It will come back to the Assembly in an undetermined time, and we may be back to square one and simply have wasted a long time. If that is the case, I don't know where we're going to get. We are coming towards the end of this Assembly. We are coming towards the end of this year. We will have the government plan. We will be so busy. Nothing else is going to get done. By next March, if things aren't lodged, nothing will happen. And the reality is the elephant in the room is if something is not lodged by Christmas, it's not going to happen in this term of this assembly. And that's a reality of where we are. So I don't want to reference anything back just simply to kick it down the road, because I don't think that's the right thing to do. However, if you want to call this in as a scrutiny panel and then analyse the detail of whether or not these things will work and how they will work and bring amendments, I absolutely agree with that. That's what scrutiny is about. So at this moment in time, I'm not sure that I can support a reference back. And don't get me wrong, supporting a reference back to annoy government a little is not, it's okay with me. But we need to think very, very carefully about what we're achieving with this. So if we can have some detail on what the actual aims of this are in taking it away again, when it will come back, and the time scale for getting an outcome from this, then I think perhaps I may be more open to this debate. But at the moment, I don't understand that. And this is a confusing one for me as to why we're referencing this back in the first place. So I hope that was clear. It wasn't as clear as normal, I don't think, but there we go. Thank you.
Thank you very much, Deputy. Does any other member wish to speak on the question of the reference back? No other member wishes to speak. Then I close the debate and call upon the Conotab of Greville to respond. Conotab, it might be helpful if you were to specify the information that you're seeking, but once again, as you respond, so members know what they're voting for.
Thank you, sir. Yes, sir. Well, with regard to consultation, we had our first briefing a fortnight ago. We'd been approached prior to that by the Construction Council, who had sent in a written submission highlighting their concerns. We met them later in the same week. And at the briefing that we had from the Minister and his department, it was admitted that there was no consultation on the conservation areas proposals. They were taken as what the states want, therefore there was no need for consultation. That surprised us somewhat, and I don't think that's adequate. It's interesting that the tree strategy group, I think, does have representation from the farming community on it. Interesting that when the minister mentioned that body, he didn't mention the farming community, and of course they manage most of the land in the island. People may or may not be aware that the amount of trees being planted by them is phenomenal, and so the dangers of losing trees in the countryside is not an urgent matter. I appreciate that, and so there's no rush for this. The reason why we're calling, we'd like to reference it back rather than call it in. And I'll first of all read out the information I think we're missing first, and then I'll finish on the final point. There are no details provided within the proposition as to what the likely impact on resources the introduction of the tree control change might have for government in terms of the planning application, permissions and appeals process. No details provided in relation to how the administration and enforcement of the proposed conservation area change will be resourced. It's widely known that the planning IHE department is short of resources, and there's no mention of what impact this will have on their budgets. No detail on how the three major changes proposed will be implemented, including governance, procedures, clearly set out roles and responsibilities for government in implementing the proposed changes. An example of this is the chair of the planning panel is meant to be on the appeal panel, or the appeal panel. Well, he's almost certainly going to be conflicted because he will have deliberated on the original application. The outcome of the tree strategy and associated consultation is unknown. That's still ongoing. Similarly, the designation of conservation areas is to be addressed in the Bridging Island plan. Again, something we're waiting for, so we have no detail on that. And we have no detail provided around what governance there will be around the proposed determining panel, how this will aid and not hinder the planning consent process, and what additional resources the administration of this may entail. But I'll finish on the point which many members raised, which was why refer it back and not call it in. And it's simply because we want to fit it into our work programme, sir. This came pretty much out of the blue. It's not on our work programme as it is. We appreciate we have to fit it in, but we want to do that in our time. And I know that all members on all scrutiny panels and PAC, the work programme for all of these things are programmed in advance. Everything is tight. We will get this work done, but we want to fit it in our time. And I don't think we were given enough warning to put it in our programme early enough. And that's why a reference back is preferable to calling it in. Thank you, sir.
Indeed. I ask the greffier to place a vote into the link. The vote will be on whether or not to refer the matter back to seek the further information as outlined by the Connétable of Brouville. Ask the greffier to open the voting and members to vote in the normal way. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The proposition has been rejected. 16 votes pour, 23 votes contre, no abstentions in the link. A further 3 votes contre in the chat, and a further 3 votes pour in the chat, with 1 notified in the assembly. That is 26 votes contre, 20 votes pour. Very well. Connétable Brouville, do you wish to continue with your speech?
I haven't got a great deal to add, and I'm not going to repeat what I've said. But for my part, I don't have the information to support this proposition, so I will have to vote against it, despite being totally in favour of what is trying to be achieved here. I want to protect trees. I actually, ex-farmer, I've got land, planted far more trees than I will ever fell in my lifetime. I only take down trees if they're dangerous, or trim them when necessary, and that goes for just about every farmer. The amount of trees that have been planted in around fields is unbelievable in my farming career. Every year, more and more trees are being planted. I appreciate there are some unscrupulous developers that demolish trees prior to putting planning application, and I can see why that is something which we must really do something about. There's no real urgency for this because that happens rarely. The whole idea is uncosted, and we need to fund it. Deputy Ward mentioned that earlier. Of course, we have to, if we're going to pass a law, we must be able to fund it to make sure that that people are compliant with it. There is currently some protection. You can't remove a hedge without permission, which includes a tree in a hedge. And the makeup of the determining panel is of concern to me. So I very reluctantly will have to vote against this legislation, sir.
Very much, Connétable. Does any other member wish to speak on the principles?
So I had put in the chat.
I don't have you in the chat, Deputy Masson, but I do have Deputy Higgins. Deputy Higgins. Above the vote. Sorry.
Thank you, sir.
No, sorry, if you could wait, please, Deputy Higgins. I'm not sure. Yes, I'm sorry. Deputy Masson sneaked in between the result and the vote, and he's entitled to speak first. So, Deputy Masson.
Thank you. So it will be brief. It's just a question for the Minister, and it surrounds, let's hope I can get this right, Part 6, Article 12, new Section 2A in brackets, which is about the determining panel. And I understand where the Minister wants it to be in the case of the Minister, any Assistant Minister of the relevant department, and the Chair of the Planning Committee. My question for the Minister is, in a situation whereby, whether it's a constituency matter or perhaps a planning application has been through Planning Committee, the issue surrounding potential conflicts for the Chair of the Planning Committee to be under law, to have to sit on this committee or the determining body, is the Minister comfortable that there is enough wiggle room in those situations? So, for example, we know members will inevitably lobby for a particular development or against a particular development, but if under the law they have to be on the committee, how is that conflict of interest going to be managed if the law determines that the Chair of the Planning Committee has to be on this? If the Minister could just explain that, I'd be most appreciative. Thank you, sir.
Very much, Deputy. Deputy Higgins.
Thank you, sir, and I will be brief as well. I'm just hoping that the constable who proposed the reference back, the Constable of Grouville, will, instead of voting against this proposition, which has got much in its merit, will, as part of his scrutiny panel, just call it in and review it. And any comments I have, I'll make at that point. So I think rather than throw the whole thing out, when it's got much to speak in its favour, we should just refer it to the scrutiny panel. Thank you, sir.
Thank you very much, Deputy Morell.
Thank you, sir. And yes, it's similar to Deputy Masson. It's more concerned perhaps about bringing in a panel to decide on large projects. And just given we've had conflicting information about when this law would come into force, would the Minister please, in his response, advise whether this is likely to come into force before the need to determine the planning application for the hospital? Because I find it interesting, because obviously he did the last hospital application on his own. And it's just with regard to the trees element of it, my main concern, I fully support the Minister's kind of intentions in this. My main concern is just about the order making power, because not so much the order that he himself may make, but it's future ministers who may decide to use order making powers to withdraw protection for trees in one way, shape or form. And it's just a reality, whether we like it or not. The orders often get missed. They're not publicised very well. Often the scrutiny panels don't always know that they've been made. And so it's just more, I mean, in my case, it's because I wouldn't like to see tree protection weakened, but it could be the other way. You could have developers or other people who are concerned about an increase in tree protection. So it's just how does he intend to make sure that those orders are seen and known about into the future? Thank you, sir.
Got a time for Trinity?
Thank you, sir. And I'd just say that I absolutely support the idea of the conservation areas and the need to provide some protection for trees, which I see the difficulty in policing that. But certainly as a principle, I'm entirely happy with that. But my concern follows the comments by Deputy Masson, which is the situation where, and I talk as being the chairman of the planning committee, I'm actually conflicted, and I can think of two current examples. One where I am on the political oversight group for our hospital, and second one would be the current one, which has just been called in by the Minister for an inquiry, being the Water's Edge Hotel. I'm slightly mystified about the criteria which actually requires these applications to be decided by the Minister. He's going to call it in. Being the public benefit of or the general impact on all islanders, whereas
I have seen other applications go through where I think there has been significant implication for all the islanders, and yet they quite happily go through the committee. And to a certain degree, I find that pulling something out before the committee have had an opportunity to consider a planning application rather undermines the credibility and authority of the planning committee in the first place. So I certainly would like to have seen a lot more work being done around this particular area. Thank you, sir.
What, Conor St. One.
Thank you, sir. My concerns are slightly different about this law in that, as the planning minister well knows, I've had having a bit of an issue with the planning department about some trees that are already protected, and I know his officers are doing their best to sort them out. But we currently have a situation where the tree is protected and has been certified as being dangerous and needs to come down, and also the planning consent forbids broncage from being carried out. So I would just ask that the planning minister makes absolutely clear that there are at least 2 exceptions in the law, and I don't think members should take this the wrong way. I'm entirely in favour of preserving our natural environment, including trees, which are an incredibly valuable asset to the island. I think you only have to look at pictures of the island after the war, where trees were stripped for firewood, to see the difference that allowing those trees to go back has made to the beauty of Jersey. But go back to the point I was trying to make. I think there are 2 exceptions. Firstly, where the broncage law is contravened by trees, I think there needs to be an exception that the owner of the land or the owner of the tree should be able to comply with the broncage law and make whatever adjustments are required by that law. And secondly, where the tree has been condemned by a qualified tree surgeon as being unsafe, both in terms of being near a public road or indeed in anywhere where it could endanger people, that there should be an automatic right to take that tree down, provided the certification of a tree surgeon is produced and can be produced after the event. So I'm generally supportive, but I'd like to see those 2 exceptions clarified crystal clear in the legislation. Thank you, sir.
Very much. Deputy Labby.
Thank you very much, sir. Yeah, I just want to elaborate a little bit further on my point about the appeals process. You know, those of us that have worked on the planning committee feel very passionate about the planning process in the island. And, you know, I served on the planning committee for 6.5 years. The process, I know it's slightly, developers, some developers are slightly unhappy with it, but that's maybe not a bad thing, actually. If they were all happy with it, you might be a little bit worried, with greatest respect to them. So what we strived, we are, in 6.5 years I was on it, absolutely scrupulous in our conduct on the planning committee. It is a difficult job because in most applications sail through and are approved or not by officers under delegated powers, and the majority of them that will be what happens. You know, a garage, an extension to a house, what have you. Where there is objections from neighbours, or if there's any controversy, or it's very large, or there's a challenge, it comes to the planning committee or it's very finely balanced. It comes to the planning committee and that process starts. And you'll have seen the application process online with all those objectors letters and supporters letters. And we make sure when we go on a site, we visit every single site, and we make sure that we don't hear representations from one side on site, because out of earshot of the other side. And it's difficult to explain that sometimes to people. And then, of course, we have our hearing in public, and we determine in public there and then. And it's sometimes really high pressure and really difficult. And there was, I think, in my early days on the planning committee, we would sometimes want to chat with one another, so we'd go into a side room and talk. And then when we came back, there was a lot of disgruntled faces, as you can imagine, because they were wanting to know what we were talking about. And we very soon stopped that and decided, although it's more difficult for us, we will have our discussions if we need to in open forum so that the public can understand our thought process. And as I said, we have to make our determination, and we have to give reasons in the planning law that we are either going with the officer recommendation or not. It's not just, oh, I think that house is ugly, I'm not going to approve it. Everything has to be based within the law, but we can apply different amount of weight to different arguments, and we have that leeway. And so it's a great process. And then if the applicant or those who are trying to stop the development wish to, they can take it. They don't like the decision, they can take it to a third-party appeal, which was brought in about 10 years ago. And so then the situation continues to be in an open forum. Most of the time, sometimes it's done, the smaller ones are done just by written exchange. But again, the fors and against have their chance to have a say, and we all know what the other party is saying. And then, so it's a UK planning inspector. It is not administered by the planning department. It's administered by the judicial greffe, which is really important. So there's no suggestion that the planning department is finding a UK inspector that they think might go with this application or not. So that was a very, very clever move too. It does take time, of course, which is a problem. And then what was built in as a third layer or fourth layer in this was for the ultimate decision. So once it's gone to third-party appeal, the UK inspector has made the decision for reasons that the prevailing thought at the time was that nothing should be more sovereign or trump the elected representatives. So basically, in common parlance, we shouldn't have a UK inspector telling the states what to do. And for that reason, it went back to the planning minister to make the final decision. And that is slightly weird, because that means the planning minister can't be involved in a lot of the detail of planning, which I've always found rather odd. And when it goes back to the planning minister, and this is what has worried me since my time on the planning committee, that process actually is behind closed doors, and the planning minister can consult who he wants, I guess, or she wants. I guess it's officers. So all of whom are absolutely brilliant and not casting any aspersions. I've really enjoyed working with the planning department, and the planning officers are fantastic. But you can see that's not ideal, is it? Because the whole thing has been transparent till then. And what I worry about in a situation, especially when we've got David and Goliath battles on planning, and there was one recently, I won't refer to it in detail, but it worried me especially. It was a big development, and one neighbour was objecting. However, it was approved by the planning committee, and it was recommended for approval by the department. It was approved by the planning committee. This one neighbour took it to appeal, paid her money, whatever X £100 it is now, paid her money, took it to appeal, the full process, put her case to the UK planning inspector. It's a big development, one little old lady, and she wins. She wins the planning appeal, and she has it, and then it was overturned by the minister. Now that strikes me as difficult, because if the planning minister was never going to side with her, why go through the whole process? You know, in that situation, wouldn't it be better if the planning minister says, look, there is no chance I am going to not allow this application. So that has worried me about the whole process, the fact that it's behind closed doors, and the fact that I think at the very least, the lady should have got her money back for the appeal, is my feeling. So I am troubled by that. I know that this doesn't specifically address all of my concerns that Deputy Young has brought in here. I will be supporting it in full. I'm so pleased that the Assembly has agreed to vote on this. I hope it goes through, because I fear that it would have been kicked into the long grass. And these are really, really important things for Jersey. Protecting our trees, making sure our planning process is open, fair and transparent. And people do leave the planning hearings often saying to us, well, it went against me, but thank you for hearing me out. And that's what we try to do, give everybody their chance to have their say. And we like them to leave feeling satisfied that they have. But I think the last area of the planning process for me needs, or even I would scrap it and just say let's go with what the planning inspector says. Let's agree as an assembly to go with that. It isn't ceding a great deal of power, but I think that's where the process should finish once it's gone to an open and transparent, independent hearing by a UK inspector who's an expert. Sometimes I don't agree with all their decisions, and it's like any planning decision, but I think that should be the end of the process myself. So I just say that in open forum so people know where I am, and I see that the planning minister is writing that down, so I'm pleased about that. But I'm really congratulate him for bringing this. It's 3 really important steps to bring us up to date and in line. Thank you so much.
Thank you very much. You have a point of order, Deputy Tadier.
Yes, it's just to ask whether or not the scrutiny panel are allowed to call this in, given that it's an amendment to a law and not a law itself. So I'm not sure in my mind whether they have the ability to do that, and that would influence whether I spoke and how I would speak, sir.
Yes, I think the scrutiny panel does have an absolute right to call in any matter such as this, and they're entitled to do it if the principles are adopted by the Assembly.
Thank you.
Very well. Conor Harbison Brillard.
Thank you, sir. With regard to trees, no one can question my eagerness to protect trees in the island, and that is evidenced by the 21st Amendment of the last government plan, which was happily accepted by members. And I, like the Minister and others, are determined to push that through as quickly as possible. But with regard to the rest of the this proposition, there are other elements in which we need to flush out the detail. It's probably best to describe that. And one particular which surfaces in my opinion is the Article 17 regarding caravans, which could be quite controversial, and I'm not aware whether we had much input from those involved on both sides of that argument. So it boils down to the devil being in the detail. I look forward with the panel to progressing that in due course as quickly as possible in conjunction with the Minister, so when the time comes. Thank you, sir.
Indeed. Deputy Guida. Deputy Guida.
Sorry, lots of buttons to switch to get to this point. Yes, I'm sorry to hear from the Constable of St. Brelade's that the panel is going to call this in. There are 22 parts in this amendment, many of which are quite important. They are fixes for things that don't actually work well in planning law. So they are quite important, and it would be a shame to have to wait more for them to happen. In terms of the 3 big ones, I think we haven't had much problem with areas of special interest. The conflicts, if a conflict arises in a determining panel, we have to remember that this is just an additional option. So basically, the minister can still determine something on his own, but he has the additional option of asking for help. And if that help is conflicted in any way, then he doesn't. So it's just an option, and really there's no problem. There shouldn't be any problem with that. And the last one was 3. Again, I'd like to remind everybody that this is just a mechanical part enabling the protection of trees. So first of all it does, it says doing work to a tree is going to be development. It's going to be considered development, and that's all it does. That's what it does in this. Also, it doesn't do it now. it does it after an appointed day act. And the idea behind that is actually to be quite open and to say, don't worry, we're not going to bring in an order by stealth. There will be an appointed day act in this assembly. This assembly is going to see what we're going to put in the regulations, and they're going to decide on the regulations. There's not going to be a very, very discreet order preventing everybody from ever touching a tree again. So this, frankly, is quite ridiculous. But it is mechanical. We need this to exist before we do the regulations. So I'm really, really sorry that the scrutiny thinks that they need to delay this for any reason. Thank you, sir.
Very much, Deputy Guida. Deputy Tadier.
Thank you. First of all, on that last point, sir, government should always know that scrutiny can call anything in for whatever reason if they feel they have a want and a desire to do that. And so it's incumbent on government to leave enough time when presenting any legislation so that scrutiny doesn't get blamed for the delay. So if anyone's to blame for the delay, it's the department, not scrutiny. And that's just a general point that applies to all government legislation. That they shouldn't take scrutiny for granted and presume that they won't call something in, because obviously scrutiny is independent. On this, I'm glad that scrutiny look like they're calling it in, and I want to raise a couple of issues which may not be central to the proposal today, but something that I've noticed just in reading through is on page 19, for example, the new article 56A, that there are some parts where the law talks about empowering the chief officer to do something. So 56A says the chief officer may designate as a conservation area any area of Jersey which there attaches a special architectural historical interest to. And it continues. And my question to the panel would be, and I suppose to the Assembly, there seems to be some kind of dilution of what the chief officer is able to do in his or her own right under this law and what the minister then can do. Because if we go down to the third part of that same article, it talks about the minister making orders for such further provision as is necessary for the purposes of this article, whether in relation to a particular conservation area. And it goes on to say that he may do that even if the chief of so 3A, specifying any activity which may be undertaken within a conservation area without the chief officer's permission. I would certainly need clarification, and it may well be that the minister will do this in his summing up anyway, about what responsibility and accountability the chief officer has in this law and in what this law will actually become, because this is an enabling law, as we know, and what responsibility and accountability the minister has. And my point of view is that I know, of course, that in every department it's possible to have delegated responsibility for either an assistant minister or even an officer, but of course that officers don't have the same level of political accountability that politicians who are elected do. That's pretty obvious, and I'm concerned that in this law, as in other laws that we have for the Environment Department, that powers have either been given or shifted to the chief officer when actually they should be lying with the minister. And I'll give one parallel example. That's the derelict buildings law. And so if a building, for example, or it could apply to glass houses, or it could even apply to walls or buildings which have fallen into disrepair, the power is being given to the chief officer to actually make a determination as to whether or not he or she would issue a compliance order of that, whereas it used to be the minister, I understand. And I find that trend, if we're seeing it in this law, is worrying, because really it should be for the minister to be making those kind of decisions where he can be accountable to the Assembly. And I think I'm not saying this is a shift in the law, but it's a new amendment here, and I would like the scrutiny panel to look into that area if they're minded to, and I'd certainly like to make those points. Of course, generally speaking, on the principles of the law, I should also add my tree loving credentials and say that, you know, many of my best friends are trees, and I wouldn't see anything done to them that would harm them. So, thank you.
Deputy St Martin.
Thank you, sir, and I won't speak for long, but I'd just like to follow on from Deputy Taddier, if I may, and talk first about the makeup of a potential panel that might make decisions instead of the minister. And as has already been pointed out, those of us on the planning committee already discussed this, and I suggested that the chairman of the committee is going to be conflicted almost entirely, because most cases that go to appeal and are then determined by the minister after an inspector has advised or suggested, the chairman of the committee will almost certainly have determined. So I don't think that's a particularly well thought out idea. But what I would say, and it follows in, as I said, sir, from Deputy Taddier, is the minister's at liberty to take advice from anybody he chooses before he makes a decision. I would certainly hope that he would want to speak to his assistant minister and his senior planning officers. And the point I would make, sir, is if the minister wants to be responsible, he should be responsible for taking decisions. If he wants to be the minister, he's the man who should make that final decision. And I agree with Deputy Taddier. I think this needs to be looked at more, because whether the decision, the minister takes advice from others and then lets that advice influence his decision or not, surely the minister is the man or the woman to take that decision. On conservation areas, sir, I'm very much in favour of conservation areas. I was when I was minister, and I still am now. And I don't think that's particularly controversial. I think when officers of the department explain that to states members and members of the public, they will understand the concept of conservation areas, which is important and could be a great asset to the island moving forward. And then finally, trees, sir. And I've said it before and I'll say it again. I think this is a sledgehammer to crack a nut, and what's proposed here is the first question that comes to my mind is, what exactly is the minister trying to achieve? Is he trying to, reduce carbon emissions, to affect climate change by allowing more trees to exist on the island? If he does, then maybe he should concentrate on trying to protect trees which are smaller and have maybe 100 years left of their life, rather than large trees which may be coming towards the end of their life. Maybe he should be concentrating on protecting trees in the built-up area so that they have a much more beneficial effect on those people who are living there, providing shade, keeping people cool, and taking some of the pollution out of the air. But if he's not doing either of those things, and the Assistant Environment Minister mentioned development in the short speech he gave, and if the minister's only protecting trees on development sites, well, I think he should come out and say that. And that's where I get the feeling that it's a sledgehammer to crack a nut. Because if he's only interested in trees on development sites, there must surely be a way of coming forward with legislation which only affects those sites and doesn't affect the whole island. Because it's my view, sir, that if we pass laws which mean we have to apply for every time we want to take a branch or a limb off an oak tree or an ash tree or a chestnut tree, that people in the countryside, those who are responsible and keep it beautiful for all of us to enjoy, will come up against a huge amount of administration and paperwork. Not only that will be time consuming, but it will cost money. If every time you want to fell a tree or take a branch off a tree, you have to pay a professional expert to come to advise you. And it will affect, in my view, sir, greatly the way the countryside is looked after and farmers and landowners' ability to keep it looking beautiful and safe for the general public. But I'll leave it there. So I will be voting in favour, but there are an awful lot of things, especially in the trees section of this proposition, which need to be looked at more closely. Thank you.
Thank you very much, David. Does any other member wish to speak on the principles? If no other member wishes to speak on the principles, then I close the debate and call upon the Minister to respond.
Thank you, sir, and thank members for allowing the debate to proceed. I think there's been good points made in those speeches, which I've certainly tried to take note of. And I think really I'm making the assumption, sir, that the panel will be calling us in. I don't think I'm wrong in that, but I think certainly that we have the way of addressing some of those points of detail under such a call-in arrangement. Just an example, for example, the starting speech from Constable of Grouville highlighted a particular point in the draft law change about, at the moment, hedges. Hedges, of course, removing boundary hedges and so on, is development under the law. Of course, what we're proposing to do is to substitute for that, because obviously that would overcomplicate to leave both provisions in. So that's one example where I think then I think where a particular point has been anticipated, which I don't want to be the case. Deputy Masson does raise a very good point about the issue of the chair of the planning committee. I think I want to make a couple of points clear about this. Firstly, a call-in application, anything that is called in by the minister does not go to the planning committee. So there is a clear difference between the conflict of the chair of the planning committee, where there should not be in normal circumstances. I don't believe there would routinely be a conflict on the call-in applications, because they won't have ever considered that application. It will have bypassed the committee. It would have gone straight. And I suppose the logic, my thinking was, if we are to have a body to share that arrangement, then the point that Deputy Russell Labby made was absolutely right, that the planning committee members do a fantastic job. They really do know their planning. They're very experienced. And I think if you are to have an extra plug, if you like, into a determining body, I think having a chairman, I think if time would have allowed, I would have changed the word. And because at the moment, what the law change we've got in front of us says is the minister and the assistant ministers and the chair of the planning committee. I would, in hindsight, would have preferred that to be or to allow for that, but that I'm hoping is an issue that if the panel, I hope, go ahead and call it in, we can deal with that. I think but there are issues, but I listened to what the Connétable of Trinity said carefully. And of course, at the time this was drafted, we had a different chair of the planning committee. And I didn't personally know that the chair of the planning committee had agreed to take a lead in the hospital project. I didn't know that. So I think this is where I could go straight to Deputy Morell's point on this. What does that mean? I think if, and it's an if in my mind, if the timing of the planning application for the hospital and if the timing of the planning inquiry into the application means that a decision needs to be made before the conclusions of the let's get this right, before the conclusion, yes, of my term of office, if nothing else happens in the meantime, I think you're right that I could not invoke, because of that conflict, which I'm now aware of. It would have to be on that occasion that I believe the minister, who's ever in the minister, deciding on their own, because I think that unless if it stays as and, that would be the case. If it goes to or, then there may be other possibilities. We'll have to see. But at the moment, on the basis, it would be the minister only. I think that provision is there, as Deputy Labby told us, for the future. it's for the future. But there's no question in my mind that the chairman of the planning committee and planning committee members, and there's 9, so conflicts do arise. You cannot remove any possibility of a conflict in planning issues. And I'm going to come back to that in a moment if I may. But so that now, Deputy Morell, I think you've asked about the hospital. And then this issue is about rescinding orders. Orders can be absolutely, rescinded. There is an order, a procedure for us to, and my understanding of that, if a member brings a rescindment motion on an order, then that order is not put into operation. There's a debate, and if it's flung out, it's flung out. It won't go into effect. Now, I agree there are problems about finding out about orders being made. I'm constantly concerned about that. I've expressed concerns about that, and it's something I'd like to see in future, make it easier for members to know what orders are being made in time to be able to invoke those provisions. But the draft is there on the basis of an order making power, and it's suggested as an order because that's the way we do with all permitted development. It's the way in which we allow extensions and windows and doors to be changed and all sorts of landscaping on people's properties. We set limits and say you can do that without consent. And of course, they were absolutely intention, what's in my mind, we would do that for trees. And we certainly wouldn't be controlling everything. It's just absolutely, it would be unrealistic. And now I think the Constable of Trinity also raised the question of criteria. Well, the criteria for a call-in application are in the law. And I think, there is this issue, I think possibly, I know the Constable of Trinity did speak to me. I hope you won't mind me mentioning this, about whether or not I should have called in the Cyril Marcon House planning application. I had decided not to do that. And I don't know. I don't know that application is currently before us, so I probably not to stay anymore. But I did have my reasons, which I think it's a question of the criteria that we have in the law for a call-in application. I was applying that. Constable St. Juan, absolutely. Of course, we automatically dead, diseased, dying, dangerous trees, trees that prejudice people's properties. I also think trees that block people's lights to their living space. Had a lady phone me up today. Those, of course, there's going to be exemptions. There'll be lots. And that's why we're doing the tree strategy work, to try and find those boundaries. Of course, it would not be sensible. On Broncars, yes, of course, Broncars needs to go on. It's a really valuable, important provision. And of course, I was very grateful to the Constables and Deputy Gida, who worked so well in getting the new guidelines on that, which was very, very good. Now, I think Deputy Russell Levy gave us a really good explanation of the planning appeals process. The whole business of planning applications, root and branch. And of course, it's changed lots of times over the years. I can remember when 7 members of the planning committee used to sit there in private and rip apart people's planning applications, and nobody was allowed anywhere near the committee. And we've gone from that, then we went to subcommittees, then we went to meetings in public, then we had the minister deciding on his own, then we had the Royal Court on Appeals. We tried every permutation. It is not possible to find a perfect solution. In the long run, my personal view, and I think the planning law has done extremely well. And has served this island fantastically. One of the most important laws, as I said. There will come a time when there will need to be a new law, I believe. That is not now. And that is the time for these appeal processes. And Deputy Russell Levy reminded us, the judicial grefg run the rules. I do remember this decision to set it up that way was done in 2014. And ironically, I recall I actually voted against it. I actually had in my mind we'd have a proper tribunal, a planning appeal tribunal with full jurisdiction. That means they can make the final decision. But that is not now. I think that's an issue. Those sort of big issues, and they're even bigger than what we've got on the table here, will be for future assembly. And that, I think, is for me, I put that there for members to think about. There is no perfection answer there, but I can promise you this. Communities have to run their own planning processes. We own this. This is us. And there's controversies, there's arguments, transparency, and so that it was an attempt to improve that. But I think it's going to suffer as it's currently drafted from, if you like, those restrictions. Caravans, Constable St Bernard. Two views on this. The current law is well outdated. Goes back to the 1960s. The 2002 law copied what was in the 1964 law, which was, we don't want caravans all in Jersey. And yet we've got different attitudes now. And because, so is it right to hard code into the planning law all rules about caravans? No. It's better to have a separate process and do them through subordinate legislation. And that is all that is proposed here. And again, because it's got an appointed day, nothing is going to happen without that detail being decided. And of course, the constables will be involved. Deputy Gila is absolutely right. No, it's the appointed day, there will be no order by stealth. Deputy Tadier, yes, Deputy Tadier, really good point. I'm grateful for what he said. I personally queried myself with the officers and with legal advice. Why are we giving powers to the chief officer to designate conservation areas? Well, I was told that, well, you're conflicted. If you're dealing with appeals, you're going to affect, once you set a conservation officer, you're going to have conflict. So it's got to be the chief officer. But of course, we've got a situation under the target operating model that the IAG chief officer, there is discussions about which post should it be. So I think what we've got is the best we can achieve at the moment. But I'm pleased, but the minister, obviously, I think it is right that the rules for within that conservation area will be decided by the minister through what's put in here. But it reminded me one of the arguments came to be, why was it the chief officer? And what was said to me was the chief officer would be required to act only on the evidence coming to them from the expert advisors. That it wouldn't be a question of chief officers thinking, oh, I like this, I'll do that. There's got to be an evidence-based process, and there obviously got to be consultation and engagement. And obviously the chief officer there would be acting in an administrative capacity. Deputy St Martin, yes, I think just to pick up the point about conflict again, please, I'm sure the Deputy perhaps has overlooked that in his speech, that there is a difference between a call-in application where the planning committee has not been involved, has not considered it. And so it would, I don't think that argument applies about conflict in a call-in application. But of course they take advice. Of course we take advice. I can't tell you how much advice I got when I had the difficult job to decide the last planning application for the hospital. I was besieged by advice. I ruthlessly listened to it all. I read every word of evidence. I listened to every piece of advice. But in the end, I thought at that time, I did my best to fulfill my legal duty and behave absolutely responsibly and objectively. And so I think it would have been helpful because to have an alternative process in the way that Deputy Labby spoke of. Sledgehammer to crack a nut, well, it's not what I want to have. I don't want to have a sledgehammer to crack a nut. And I absolutely go with the idea of concentrating on built-up trees in built-up areas. Absolutely. They are so important. And so, look, what people might just say, well, why have you included it as development? Because that's the way the law works. The planning law only controls development. If it's not development, you've got no control over it. Simple as that. And that's why it's done. No control in the law. And so you have to put it in the law, and then you then make the rules to accept it and set them out. So, sir, I make the proposition for in principle, sir, if I may.
Would you give way for a point of clarification from Deputy Burrell, please?
Yes, sir, of course.
Thank you, sir. And it was just you talked, the minister talked about calling applications and said that they don't go to the planning committee. But of course, some applications are called in by the minister after having gone to the planning committee. And there was one in Grouville last week or recently that was called in by the minister to, at least it was seen by planning inspectors after the planning committee. And indeed, there's another, it's just gone out of my head suddenly, but there are other, Gas Place, the second Gas Place.
Is this a
so
point of
could the
clarification
minister
you're
clarify that not all planning applications that are called in by the minister do not go via the planning committee, because some indeed do, so.
Well, sir, I think I don't recall that while I'm a minister, I've ever, once the matter's gone before the planning committee, I thought it was irresponsible to interfere with that process. And so I've not done so. I can't recall it. I don't recall I've knowingly done that. But an application is, it doesn't mean to say that site has never been considered by a planning committee. I view it as a separate, each application has got its own identity. It's not uncommon for major schemes, major developments to have 7, 8, 9, a dozen applications. And each has to be judged on its merits. What one shouldn't be doing is saying, oh, here's a scheme now, I'll decide this on its own, but I'll have a look at what went last time, the last one.
Well,
sorry, sir.
I think we might have gone beyond the point of clarification again. Very well. The vote then is on the principles. I ask the greffier to put a link into the chat. And ask the greffier to open the voting and members to vote in the usual way. Sorry? I don't understand. Okay. Are you not able to vote in the normal way, Conatel? Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The principles have been adopted. 39 votes pour, 1 vote contre, no abstentions in the link, a further 3 votes pour in the chat, and 2 votes pour indicated within the assembly.
Could we have the one, sir, please?
Yes.
The vote contra was the Constable of St Mary.
Very well. I take it that the Environment, Housing and Infrastructure Scrutiny Panel wishes to scrutinise the matter?
Yes, sir, we do. The concept of coming back to that on the 19th of January.
19th of January.
May I propose the adjournment?
Very well. Very well. So that's into scrutiny, returning on the 19th of January. The adjournment is proposed. Very well. The Assembly stands adjourned until 9:30 tomorrow morning.
Great.